My lord, Mrs. Mallard was appearing before the Honorable Justice Sugato Majumdar, my lord. But my lord, the interim order, my lord, has expired.
Have notice upon the other side.
My lord, I am mentioning upon notice.
Inform that it will be taken up at 2 p.m.
Hello, this is my matter, which was filed subsequent to your lordship's leave.
You have annexed all those.
Yes, what I have annexed, I'll just briefly indicate so that it's easier for my learned friend to also argue. First and foremost, I have disclosed the order by which the receiver was appointed, the party receiver, that is 29th of August 2019, which is at page number 8 of the application. Then your lordship will find the correction implemented to that, which is at page number 10, the order dated 2nd of September 2019. Afterwards, I have indicated the written statement or the application which was filed by my client before the Industrial Tribunal, which is Annexure B at page number 12. Then your lordship will note,
The written statement.
yes, there the application is called as written statement. That is why it's the nomenclature used is written statement, but it's otherwise the application which was filed by my client before the Industrial Tribunal. Then your lordship will note GA 16, which was the earlier application that I had filed before your lordship, where the defect was there. I had taken out the notice of, instead of master summons, I had filed with the notice of motion. So that application I have annexed as Annexure C, which is at page 21. Then your lordship had passed the order directing the parties to file the respective pleadings, affidavits. So that order I have annexed at page number 27. Then your lordship will find affidavit in opposition to my application, which was filed by the receiver. 27 is your lordship's order,
Yes.
by which the direction was given. Then page number 30 is the affidavit in opposition to the earlier GA which I had filed, taken out by my learned senior friend for the receiver. Then your lordship will note the reply to that is Annexure F, which is at page 54.
Yes, 16.
Yes, the earlier GA which I had
Yes,
filed.
this is the opposition of the
Yes.
receiver.
Yes, opposition of the receiver, which is Annexure E, starting from
But
page
you
30.
reply.
Yes, and then to that I have filed my reply, which starts at page 54 of the application. Then your lordship, yes, 54 is the reply to the affidavit in opposition.
Yes.
Then your lordship will note the written, I have disclosed the charter of demands, which is forming basically part of the affidavit in opposition to the GA 16 filed by the receiver. The correspondence which are relevant, I'm just pointing out on merits. These are all on merits. The charter of demands, which is at page 36, disclosed by my learned friend in the affidavit in opposition. Then the show cause notice, which was issued by the receiver at page 37.
36A.
36A is the typed copy. I think it's a better legible copy. Then 37 is the show cause, which was issued
Yes.
by the receiver. Then your lordship will find there was a police complaint filed by the receiver against my
Okay.
client. That is 38. Then reply to show cause is at page 67. Yes, that is the reply to the show cause by my client on 30th of November 2023. And termination of service by the receiver after a month on 29th of December 2023, which is at page number 39. Additionally, my lord, I had not disclosed this document earlier, which,
Nine.
yes, page 39 is the termination. Yes, issued by the receiver. Your lordship will see that the signing off is by the concerned lady
Yes.
as the sole receiver of the estate. Then your lordship will note there is an additional document which I have disclosed at page 69. This was not there earlier, but a reference of this was there in one of the correspondence disclosed by my learned friend. This was a written apology written by my client which was not accepted. One of the points urged was that my client has uploaded in social media certain confidential information pertaining to the estate. Now, what I had submitted was that it was a WhatsApp status. By mistake, he had uploaded, but it
It's okay.
yes. So this is on merit. I am only indicating what correspondence and documents
It
exist.
will not be decided.
Yes, this will not be decided because this is a subject matter which is pending before the industrial tribunal. All that I had to show, and I think I have been able to satisfy your lordship, is only limited to the fact whether I have a bona fide cause of action against the receiver or not. So
Anyway, you have submitted on the last occasion.
yes, that his termination of employment by the concerned receiver in the capacity of a receiver, I'm a third party to the suit, whether I'm entitled to take out the application.
One thing is this regarding service of notice or copies upon the other defendants and plaintiffs, whether apart from the receiver, are they parties before the tribunal?
They are not parties before the
They are
tribunal.
the parties definitely.
But even then, because
copy
they
of
had
it-
created a lot of objection on the last occasion when I was making my submission, I had ensured that the plaintiffs are all served. But unfortunately, so far as the defendants are concerned, one of the defendant is dead. He is not there, so he could not be served. And the other defendant, the address which is provided in the cause title, we tried to serve, but that he is not available at the concerned address. But apart from that, all the plaintiffs have been served.
Okay, the plaintiff number 2 is the receiver.
Yes,
You
plaintiff
have
number
served the
2.
other plaintiff.
I have served all the other plaintiffs. I have filed also the
One of the
affidavit of service.
defendants you have served.
No, I have served only the plaintiffs. So far as the defendants are concerned, defendant number 1, your lordship will note that he has passed away. So that service could not be affected. Then, so far as defendant number 2 is concerned, he is not available at the concerned address, which is available at the cause title. So that is why the defendants could not be served, but all the plaintiffs have been served, irrespective of the point that they are not the necessary parties, because they are not party to the proceeding before the industrial tribunal also. And your lordship will kindly take the master summons which I have taken up. In the master summons, my prayers are leave to sue, the first prayer, leave to sue the receiver on the cause of action, as I have pleaded in the affidavit in support of the master summons. Then B is leave to continue with the proceedings before the industrial tribunal against the wrongful termination of the employment of the applicant by the receiver. So these are the two principal prayers. C is ad interim order in terms of prayers A and B. That's all I'm seeking before your lordship. And I have relied on one judgment, which your lordship had already taken note of. This is Everest Coal Company Private Limited versus State of Bihar.
78.
Yes, 1978, Volume 1, Supreme Court Cases, page number 12. I had relied on paragraph 4 of that decision. It has been followed also subsequently, which I have not placed before your lordship. Let my learned friend meet my arguments, then if necessary, I shall cite those.
Yes, Mr. Mani.
No, so far the first is, so the service of this application is concerned. Now it is in the master summon. There is no dispute problem in that. Now it can be taken in the chamber. Now, so far as the service is concerned, my lord, my instructions are the plaintiffs have been served.
Yes.
They're
You are
the,
representing the receiver. That is
I'm
plaintiff
representing
number
the,
2.
yes, but the difficulty is it's a party receiver. It's the not a member of the bar. It's a party receiver in a
The
partition
court,
suit.
court,
It's a
we
court's
have-
officer.
Yes.
It's a court's officer.
Court having trust has
Yes, yes,
appointed as the
100%,
receiver.
100%. Now, this order of appointment of the receiver, I'll meet the answers of my learned friend also, my lord. The order of appointment of receiver, which is at page 8 of the application, this order records that on consent of the parties, the party receiver was appointed. This is Chakravarti's order on 29th of August.
Yes.
Now, the erstwhile receiver has died, was the plaintiff number 3. And in his place, the first page is submitted by the applicant that due to his ailing health, he is not in a position to discharge the duties of the joint receiver in respect of the estate of late Devi Prasad Mukherjee.
Yes, which page?
8.
Page 8. Yes.
But the last paragraph, second paragraph, it is submitted by the applicant that due to his ailing health, he is not in a position to discharge the duties of joint receiver in respect of the estate of Devi Prasad Mukherjee. He has prayed for allowing the plaintiff number 2 to act as a sole receiver over and in respect of the estate. Copies of the application as well as copy supplementary affidavit affirmed on such and such day by the applicant have been served upon the parties to the partition suit, as well as the heirs and representatives of the deceased plaintiff number 3. It is submitted by the applicant that all the heirs of the represent deceased plaintiff number 3 are mentioned in paragraph 14 are major and sui juris. Considering the above made supplementary affidavit, the department is ready to record the death of plaintiff number 3 and substitute the person's name in paragraph of the supplementary instead of deceased plaintiff number 3. In view of the fact that none of the other beneficiaries of the estate of late Devi Prasad Mukherjee has approached this court to object the appointment of the plaintiff number 2 as a sole receiver, there shall be order in terms of the notice of motion. So the tenor of the order, this order is passed on consent of the parties to a partition suit.
Yes.
Since then, I am acting as the receiver in the estate. Today, my lord, there are allegations against me. If my lord's pleasure to see the petition, now the only difficulty which I am facing,
Allegations with regard to administration of the property in the suit, or allegations confined to a particular act, particular order passed by the receiver.
I just see the
If it is
pleadings.
allegations for removal or malpractice,
Yes.
whatever it is, then this court has jurisdiction and court shall interpret it strictly. But
My lord.
it is only with regard to the termination order, whether he has passed it arbitrarily or
Yes.
unilaterally. Or
Yeah,
whatever.
yes. Now on the pleadings, my lord, because on the pleadings that today, my lord, so far this application is concerned, lordship will kindly record in my lord's order, whatever the order goes, that so far this application is concerned, there is no affidavit in objection. Because the affidavit in objection which is filed, the opposition, which is filed in the earlier GA. The affirmation date is earlier.
No, that is.
Yes, so I will
clear.
kindly record this because for the lawyer's safety, because today I don't know what happens tomorrow. The lawyer may change his take away the brief from my advocate on record and me also. So the issue will be cropped up in the appeal court or whatever. I'm not in that wherever. There is no opposition filed. There is no opposition filed to the application. So that to that extent, as a lawyer, we must be protected. That is the only thing, because the opposition in the earlier application and lordship is not allowing me to file a opposition to this application, because affirmation date is earlier date. So that protection I will be beseeching your lordship will kindly give me. Now, on the pleadings of this application, my lord, she wants the gentleman who says that he has been wrongly terminated from service. Now, he in paragraph 6 refers that the present receiver has adopted various unfair practice, which ultimately resulted in my illegal termination. Paragraph 6. Now, apropos to this, Lordship will kindly take the judgment which my learned friend has cited.
Judgment is yet.
So he says that there are unfair practice done by my client, by my client.
Yes.
Will-
Do you have a copy? Another copy of the judgment?
Yes, Your Lordship, I do have.
Oh, আমাদের তো আবার
Yes.
So, on these pleadings, the receiver has adopted unfair practice, which ultimately resulted in my illegal termination with effect from service. I had no option than to write to the Labour Commission. Now, in this judgment, my lord, Justice Krishna Iyer is recording that paragraph 2, receiver is appointed by this court under Order 40, Rule 1. Paragraph 2 on the first page,
Yes.
page number 13, if it is the truth. Briefly set out, the case of the plaintiff is that he had entered into a contract with the receiver, so it has been appointed Order 40, Rule 1. The same in my case. Now, after narrating these facts, the Lordship will kindly come to paragraph 4. Some 5 lines from the top in paragraph 4.
Yes.
Any obstruction or interference with the court's possession sounds in contempt of that court. Any legal action in respect of that property is, in a sense, such an interference and invites the contempt penalty of likely invalidation of suit and other proceedings. But if either before starting the action or before its continuance, the party takes leave of the court, the sin is absolved and the proceeding may continue to a conclusion on the merit. Now the next line. In ordinary course, no court is so prestige conscious that it will stand in the way to a legitimate legal proceeding for redressal of relief against the receiver, unless, which will kindly mark, unless the action is totally meritless, frivolous, or vexatious, or otherwise vitiated by a sinister factor. So these are the conditions once the court is granting a leave, we'll have to take into consideration that it is not totally meritless, frivolous, vexatious, or is vitiated by any sinister factor. Grant of leave is the rule, refusal the exception. That I am not at all. That you need to take a leave of the court, but what I am on, leave is not a mere formality. It is not like a partition suit or injunction which we say a matter of course. So leave of a court when you want to sue a receiver is not a matter of course. So you have to meet these answers, whether it's the court will have to look into meritless, frivolous, vexatious, and vitiated with a sinister factor. Now,
should not be very rigid with regard to the grant of leave.
100%. Now, leave is a rule, refusal is an exception. That is, yes. Now, paragraph 7. Paragraph 7 quotes a passage from Mullah. But it says, the italics portion, with the quoting, a receiver cannot sue or be sued except with the leave of the court by which he was appointed receiver. A party feeling aggrieved by the conduct of a receiver may seek redress against him in every suit in which he was appointed receiver, or he may bring a separate suit against the receiver in which he may obtain a leave of the court. Now, there is no statutory provision which requires a party to take a leave of the court or sue a receiver. Now it goes down this, but the court has the power to take a leave of the court. Now
he is silent with regard to that.
The legal system of India is silent. Yes. There is no under any law of the land, there is no provision. But the courts in India has adopted this system.
Yes. This principle.
This judgment is saying, this Anglo-English principle or something, this judgment is also said. Justice Iyer has said this. Now, once we quote from Mullah, the last line of that italics portion, Mullah, the grant of such leave is made not in exercise of any power conferred by statute, but in exercise of the inherent power of every court possesses to prevent acts which constitutes or are akin to an abuse of its authority. So the court will also have to see that this granting this leave should not be constituted, but should not constitute, or it should not be akin to an abuse of its authority. Now, on these principles which Justice Iyer has laid down, my lord, in this Supreme Court decision, now once we come back to this, on the pleadings of this case, keeping these four corners of what are the factors the court will have to satisfy itself before granting the leave. Now, if I take the court through the pleadings, in the pleadings in the petition, he says, I have adopted unfair practices, resulting in my illegal termination. Then, my lord, he continues, then he says that he has approached the labor commissioner. What is his last drawn salary? I am not on that. Now, if we read further, my lord, in paragraph 13, she said that there was some wrong done by the gentleman. He admits. For that reason, he has tendered apology. There's some wrong done by that gentleman. He tenders apology. Whatever, whether there is a WhatsApp communication, his social status, he admits there is a wrong done by him. He tendered apology. Now,
so this is the only new document.
New document, yes. The new document is paragraph 69. The new document.
No, para 13. This new
yes,
paragraph.
Yes, my lord. So this para 13, annexure G is the only new document.
New document.
Yes, which is the new document which comes in now, my lord. So that is the reason I said, my lord, because once this is only a change in format, but I'm not using an opposition, but only will.
No, this is the additional fact.
Yes, this is the additional fact, additional pleading in support of that. So tomorrow the lawyer should not be hauled up that you have not asked for an affidavit and the application went, whatever is the way. I'm not, I don't know, but whatever is the way it goes. So I should not, this lawyer should not be hauled up. Now, my lord, what he does, he, in my opposition, which I have filed, my lord, or should now kindly see my affidavit in opposition with page 28. Page 28 is the opposition. Now, I'll take away straight the pleadings. I've done the pleadings. Page 36 is the annexure to my opposition. Now, keeping in mind that this vitiated by any sinister factor, which is the language used in the 1976 judgment. Now, this gentleman, he creates a union. He goes to the Calcutta Shop and Establishment Union. He gives the charter of demands.
What is there from the documents?
Nothing.
Page 36.
No, 36. Where do you get that? That he has
He
he has made unions and all this.
Yes, that's my pleading. That's my pleading.
Anyway, so
That's my pleading.
does not say so.
I'll show you this. There is my pleading in support of this.
Yes.
Now you will see that that's my pleading. I will read the documents first. Now the employees of your establishment, now is a charter of demands with regard to the increment of fees.
Okay,
Salary.
apart from the replying to the show cause notice, did you call this person for a hearing, personal hearing?
No,
Apart
there
from
is
this show cause,
no.
reply
Apart
to
from
show
the,
cause notice.
as far I understand, Malad, there is
So
no
there is
pleading.
nothing on the record.
There is nothing on the record. There is nothing on the record. I should not say whether a hearing has been given or not, whether they have a rules or regulations, because it is a building in Brabant Road
After all,
on which I am in control of management of this building. Now, Lordship will kindly then in that event, Lordship can see my pleadings in paragraph 5 in support of page 36. Which resulted up to an FIR being done.
paragraph 5.
Paragraph 5, page 32. This gentleman was inducted as a typist. He continued till December 23. Now, he initially uploaded confidential information and details of the Mukherjee house in social media, causing harm to the estate. The petitioner admitted such mistake. A show cause was issued. The receiver took necessary steps against the delinquent person. Against the delinquent person. The petitioner on 21st December brought several outsiders claiming to be members of some union and started harassing and creating chaos and disturbance in the egress and egress of the building. The main entrance of the building was blocked by several trade union people. This created a disturbing atmosphere in the building. The situation became grave and serious. There is no registered trade union in the said building. The receiver has no knowledge about any employee of Mukherjee House being member of any trade union. A police complaint was filed. In order to maintain law and order and to prevent breach of peace, the receiver was compelled to file an application under 144 of the Criminal Procedure Code before the competent lord. The so-called union has given a charter of demand earlier on behalf of the staff of the Mukherjee House. The same is signed by the General Secretary of the Union. All demands are frivolous, unfounded. The petitioner's only intention is to harass the receiver. The situation was brought under control only after intervention of the police authorities by virtue of the order passed by the competent court of law, the copies of letters. Now, this is the ground reality which is happening today, my lord. Today, I'm the receiver I'm the officer of this court. I am in charge of administration of this building. Now, I have also said what is the nature of the lordship will kindly come to paragraph 3. What is the work I do? This is a building at 17 Brabant Road.
Paragraph 3.
Paragraph 3, page 31. The seven-storied building at 17 Brabant Road, of which a partition suit is pending. It is approximately 22,000 square feet area. Entirely commercial building. There are more than 12 tenants in the building. I've inquired, Malad, there are nationalized banks also in this building. It's a huge property. There are more than 12 tenants in the building occupying various portions. As a receiver, I collect rents and other maintenance charges from such tenants and occupants as part of my duty for maintenance and preservation of the building, which is the estate. There had been no complaint from any quarter, particularly from the occupants' tenants of the property, about any mismanagement or dereliction of my duties as a receiver at any point of time. Insofar as accounts are concerned, I'm regularly, that's between me and the court, filing of the accounts. So today, my lord, one of my employee, who was a typist, he approaches the court. He has been rightly or wrongly terminated. He approaches the court. Had he asked simpliciter a leave of the court, that would have been a different issue. I have made a case in opposition that he has been told, you don't come, his termination is terminated. Now, Lordship will have to also see the conduct of this gentleman, what he is doing over there, not himself alone, with the instigation, he is instigating others, with the other members, and keeping in mind, oh, this is a very problemsome machine. Off kora jay na. Keeping in mind that this machines keeps on getting shut down. Now, keeping in mind whether this action is vitiated by any sinister factor. Now, today, my lord, so these are the complaints before the authorities, the police complaints which I made, and then he comes before the court and seeking a leave of the court and seeking a blessing of the court to pursue the proceeding against the receiver before the authorities. I have annexed the show cause notice, which is at page 37. The show cause notice, the police complaint, page 38. They've annexed those documents, my lord. Page 39 is also the show cause notice, and then reply to the apology notice. Page 37, 38, 39. Page 39, I have specifically said that the proven acts of yours are grave and serious, and your subsequent conduct of bringing outsiders, page 39, outsiders with intention to disturb the peaceful working of the office, made you unbecoming of an employee, and the sole receiver has lost confidence in you. On the contrary, your past conducts are very bad, and you have been found to be of habitual latecomer. Therefore, the appropriate punishment in your case will be dismissal of your service in order to deter others to commit such misconduct in future. Accordingly, you are hereby dismissed with immediate effect. Collect your final dues. So, along with, in addition to he being terminated, he is creating an atmosphere in the property which is run by a receiver and officer of the court.
Had it been a case of
simpliciter, he is leaving
allegations,
without allegations. He is coming here asking.
Nothing to
There's
say.
nothing to say. I have made a police complaint. Police has come. Police
assuming all these things are there, but that paragraph would not have been there, that the receiver has committed.
Yes.
You are insisting upon that paragraph.
Yes. Now we'll come back to the pleading once again. Yes. Now, paragraph 6. Now, to answer this, now this says the property does not belong to me alone. I am a receiver. I am also a co-owner. So what are the others owners are saying? The plaintiffs are served. Now, what are the defendants saying? Because it makes out a case. So I have two hats. One is a party to the suit, a co-owner, as well as a receiver. So to answer this, that I have adapted to various unfair practice, because this unfair practice must be apropos to the order of the court by which the court has appointed me. Because I had said there has been no dereliction of my duties. There has been no complaint from any quarter for last 7-8 years. I am functioning since 2018 or 2019. I am functioning. So, and this action of the applicant today, how the other defendants in the suit are looking into it. Because how the other defendants in the suit are looking into it. As far as I am aware, Mala, today, the defendant number 1 has expired around a month back. The timeline has not yet, month or 45 days back.
That is for you to
yes, Mala, but I am, as a receiver, I must indicate, Mala, the defendant number 1, the defendant number 2, she has attempted service, but I don't know whether Whether she has said that she's not available in the address, that I can't say. But so far defendant number 1 is concerned, I know the gentleman had passed away around 45, 50 days or 60 days back. That I am aware. So on these facts, my lord, I beseech your lordship, my lord, so this application is a frivolous approach by the and my lord, the next date before the tribunal, because it was previously there was the last date was so near in this month of May. Today the next date is in July, 7th of July. So on these facts, lordship will have to weigh, according to my respectful submission, my lord, whether it is a sinister factor, sinister approach before the court, because he takes a leave in a situation, lordship will kindly appreciate, he takes a leave of the court and then goes before the tribunal and creates the ruckus in the property, continues to create the ruckus in the property with the union members and all these things. So that will affect the
removal order is there, okay? Now, unless the removal order is set aside, this person cannot go into that property. Only thing is this, unless the court orders, the tribunal orders, any interim protection. But so long this person is removed, that removal order remains. How can he enter into the property?
My lord, he is doing it. I have recorded that he is taking with the advantage with the other
This
union.
court is not granting any sorts of advantage to him. Only the court has to consider whether that leave has to be granted or not. Whatever order is to be obtained, whether
Yes, whether
interim or final from
yes,
the tribunal.
from tribunal. In the event, my lord, I am just alternatively, in the event lordship is not with me and is granting a leave, because lordship has said the court should not be prestige, the language is prestige conscious. The court should not be prestige conscious. The exact language as is higher. In the event the court is granting that leave, some of the observation of my lord that this leave is only some checks and balances. This leave is only restricted to moving, because this leave should not be used as a tool or a handle before the tribunal. The High Court has granted merely. Lordship will kindly appreciate a tribunal and the High Court's order.
Once leave, he cannot proceed.
Yes, I know. But in the event lordship is
It will be decided by
yes,
the tribunal.
lordship will kindly and granting a leave should not be used as a handle in the property in question.
It has to be clarified that this court has not gone into the
Merit of the matter, not in the merit of the complaint altogether, and this will not be given as a
all points will be left
open to the tribunal, and no ruckus in the property should not be done. And I have a liberty to, without saying, maintain the property in the way I am doing. In the event lordship is.
So far, you see, this person is now out of the property.
Practically.
So unless he gets some entry, there is no scope.
Well, the door is ajar. Now is union members in Brevon Road. So it's not what
you as a receiver can take necessary.
Yes, I have taken.
If your function is hindered or obstructed in an illegal manner, definitely you can
My lord, may I just respond?
Yes.
My lord will kindly straight away come to paragraph 14.
The number 1 representative.
The defendant number 1 representative.
The one who has died, yes. Today, my lord,
You are not brought into the record.
Today, my lord, I'll just indicate. In the earlier they had obtained, they were not party. The applicant was not a party. So obviously, they could not have obtained the leave for a short cost title and
Yes.
the application.
Yes.
After they received the affidavit in opposition from the receiver, they got the entire cost title. After they got the cost title, they did not take the step to serve a full fee.
No, that is not correct.
You see, the plaintiff.
I have no qualms with that.
That is not correct.
Anyway, whatever you
Anyway.
That application for some technical defects that went back. Now, my lord,
Now the question is,
when
see, after you are implemented as a party, you will get all liberties.
my lord, when GA17 was filed, my lord, against
The court is not standing in the way of you being added as a party.
Yes.
But so far this application is concerned,
on the merit of this application, 2 paragraphs. My lord, kindly takes the.
I shall record your objection that although you have claimed yourself as a legal representative of defendant number 1 and objected to the said application, but you are not implemented till today.
But not only that, may I say 2 things on the merit of
Yes,
this
yes,
application?
yes.
Kindly takes page number 3 of the
Yes.
application. Paragraph 2 is very important.
Yes,
Paragraph number 3, as I just mentioned, the
yes,
paragraph
yes,
number 5 is more important.
yes.
My predecessor in interest, mother. That can you take para number 5?
Yes.
My predecessor in interest was one of the receivers. Before that receiver was in possession. There were two receivers in the property. That is R.T. Mukherjee since deceased and S.P. Mukherjee. This is also since deceased. Para number 5. Number of kindly see what has been pleaded, mother. As far as I know, the erstwhile joint receivers, namely R.T. Mukherjee and S.P. Mukherjee, had framed rules and regulations for the betterment of the employees of the organization, which the present receiver had refused to follow after taking charge of the building. Now, my lord, succinctly, my lord, my predecessor in interest was a receiver and was involved in the framing of the rules which guided their employment. This is their statement.
Anyway,
Whether this
the
receiver is
present
following
receiver,
that or not, my
the
lord,
present receiver has taken care to deal with these allegations.
no, my
Okay.
lord, whether the present receiver is following this or not, I
The
would be in a
present
very
receiver, the present receiver
Present
has
receiver
taken
as well.
care of all these allegations. Okay.
Madam, may I just
Anyway,
respond?
just yes, who is appearing for the plaintiff?
But I am hearing.
No. Other plaintiff.
This is
Plaintiff.
my advocate on record. The same.
Same.
Oh, you are representing the receiver.
I am representing the receiver.
Fill us all.
Plaintiff number 1.
Oh, I don't. I have only vocalatama of plaintiff number 2.
That means for the of the receiver.
My
and the
lord,
plaintiff
my
number.
lord.
You are claiming yourself to be the legal heir of
Yes, sir.
defendant number 1,
Yes,
who is dead.
yes. And at present, I am not a party in the
Yeah,
industrial
state-
tribunal proceeding.
Not
You did
required.
You just complete yourself.
That's up to
That is
him.
up to you.
That's up to him.
But you first of all incorporate yourself as a party. Yes, please reply.
My lord, so far as the arguments advanced by my learned senior friend on the other side, kindly come to paragraph number 14 of my application. I think a lot has been said about the merits of the case. Paragraph 14. What is the cause of action pleaded before your lordship today? I say that I'm just placing it before your lordship. I say that the cause of action arose on and from 29th of December 2023 when the receiver terminated my employment illegally and wrongfully without following due process of law. My cause of action is entirely the wrongful termination of employment at the hands of the receiver, and as such, I have filed the instant application for leave to sue the receiver. So the entire gamut of facts and the scope of the facts are limited only to paragraph 14. Your lordship need not go into the merits of the case. Whether my termination is right or wrong will be decided by the other forum. And whether the allegations against my client are genuine, bona fide, etc., that is also to be decided by a separate forum, not by your lordship at this juncture. Your lordship is only to consider whether I'm entitled to a leave to sue or not. A very innocuous prayer, but yes, I have to show my bona fide, and for that I have disclosed the termination letter. The additional document which has come up before your lordship, which I had very fairly pointed it out before your lordship at the opening arguments itself, page number 69, which was the written apology. On merits, I'm just addressing once because the written apology is referred to in the termination letter, which is at page number 39. If your lordship kindly turns to page number 39 once, which is the termination done by the defendant number 2 in the suit and the respondent number 2 also, the sole receiver who has issued the termination letter. Your lordship will find the reference of that letter. Our show cause letter dated 24th November, your reply dated 13th November, comma, your apology dated 16th November. In all fairness, because all the other documents were disclosed by my learned friend in the affidavit in opposition, this was the sole document which was missing out. So I have only disclosed it. It's not a fact that this apology never came. It is there on record. It was there at the contemporaneous timeline. I have disclosed it, and it also finds reference in this document itself. So there is no prejudice is caused by this additional document which I have disclosed in my application at this stage. Is my respectful submission. Then your lordship will see paragraph 5 of my affidavit in opposition, wherein I have dealt with the merits of the case as has been pleaded in the affidavit in opposition to the application. However, that is not too material, but affidavit in reply for lordship will turn to page number 55 straight away. 55 at page 56. Paragraph 4 of my affidavit in reply. Why is this crucial? Is only to give an outline of the cause of action that I have made out before your lordship. Paragraph 4 of my reply at page number 56. The fact, I'm reading out A to E before your lordship. The fact that the employment of the applicant is terminated is not in dispute. B. Fact that termination of employment is at the instance of Chandana Banerjee, the sole receiver, is also not in dispute. C. Whether such termination is just or unjust is a matter of merit to be decided by the concerned forum in which the proceeding is ongoing, which cannot be made a subject matter of this instant proceeding. D. The instant proceeding is taken out only for the purpose of obtaining leave to sue in terms of the settled proposition of law, which can either be obtained before institution of a proceeding against the receiver or during the pendency of such proceeding, subject to the condition that leave is sought from the honorable court which appointed the receiver. Then E, one of the contentions in the opposition taken out by the deponent in the case pending before the industrial tribunal, that I have not approached this honorable court for leave to sue. And F, now that the applicant petitioner has taken out the instant application for leave to sue, the said deponent in the said affidavit has contended as to the merits of the complaint, which in my respectful submission is beyond the scope of the reference. So the entire cause of action, whatever, whether the receiver is properly discharging its duty, her duties or not, is a subject matter or with which I am not concerned at the moment. I'm only concerned with whether the termination is rightful or wrong, and only limited to that, I'm seeking leave of your lordship to continue with the proceeding that I have already initiated. These are my respectful submission of your lordship.
Learned counsels for the petitioner and learned counsel for the receiver, if party number 2 are present. Other plaintiff number 1, 3, and 4 are not represented in spite of service of notice. It is submitted that the defendant number 1 died and defendant number 2 could not be served. So, in the as this application is sought for to obtain leave against the receiver to sue before the industrial tribunal, service of notice upon the defendant number 2 is dispensed with. As learned advocate, yes, what is your name? Aditya? Learned advocate Mr. Aditya Chakraborty submits that he is for the he is the heirs of deceased defendant number 1 and he is objecting the same application. However, as the heirs of defendant number 1 is not brought on the records, the contention, the submission of the learned advocate cannot be recorded at this stage. The withdraw learned advocate for the submits that although he had used an affidavits in the earlier application, being, what was the application? GA 16.
16 was the earlier.
Yeah.
GA 16 was the earlier.
Of 2025 on the self-same facts of the case, but he intends to file an affidavit in this application also. However, considering the fact that earlier affidavit has already been used by the receiver with the said applications which are brought on record, and the earlier application was dismissed for some defect, this court is of the view that the said affidavits may be considered for the purpose of this case. Thus, to expedite the matter, separate leave is not granted to file affidavits. Learned advocates have concluded their submissions. Let this matter appear for orders on 16/6/2025. Learned advocates may file short written notes of arguments honored by
আগেই দিয়ে দেবো
23rd,
20.
day after tomorrow.
Lordship is still on 16th.
The order will be passed on 16th.
So can we give it on reopening day or Lordship will Lordship may use the vacation.
Okay,
Use
written
the
notes of
vacation.
arguments by 13. Anyway, by 10.
10 yes.
It ends.
Yes.
Yes, yes.
আচ্ছা না করে দেবো করে দেবো
I'm keeping it for orders on 18/6.
Yes, yes.
Great,
That's
good.
what.
18 করে দেবো মানে
তাহলে 11 করে দাও।
না না করে দেবো
I have recorded your name and objection
রেকর্ড করেছি
that you have objected, but you are not brought on the record.
Yes.
Thank
Great.
She won't be in India.
Okay, the tribunal date is in the month
Yes,
of
yes,
July.
that's yes.
So,
I mean,
July.
deeply obliged, my patient hearing.
is to other side.
Item
71.
71.
Today the matter was fixed for witness action. Witness has come on the previous day, but today due to he is not be able to come because he is very sick. He has
You're
said,
for
I am for the defendant, my lord.
your witness.
My witness, and she is for
Your
the
lordship, I'm appearing for the plaintiff.
only if it can be taken after vacation with my lord.
Yes, item number 71. Learned advocates appearing for the parties are present. Mr. Banerjee appearing for the defendant. Defendant number?
All defendants.
For the defendants submits that his witness could not come today due to illness. Stop. Thus, this matter stands adjourned till 23/6/2025 at 3 p.m.
My lord. Grateful.
May I have your lordship kind leave, my lord? My lord, I'm praying for leave to file an application in a testamentary suit. My lord, it's been notarized. The department isn't accepting because, my lord, the notary is of Muzaffarpur. My lord, the respondent number 5 who I'm representing is situated outside, my lord.
You are
Leave-
praying for leave for short service.
Leave to file the application, my
Okay.
lord. Right, I mean,
Short service.
হ্যাঁ মানে এটা just
ঠিক আছে, leave grant.
কি নিচ্ছেন?
করার হবে। ঠিক আছে, বলুন।
With your lordship's kind leave, may I be permitted to mention upon notice a matter from the determination of Justice Mojumdar. I am told that he is unwell and perhaps is not sitting.
What is the urgency?
Lordship, the urgency is that the interim order is expiring tomorrow. It was last extended by your lordship itself, but thereafter the business of the court did not permit the
Okay,
matter.
at 2 p.m. it will appear.
Today,
Yes.
Alright, it's expiring tomorrow. My lordship can keep
lordship
this
may
matter
keep with us
tomorrow.
to be mentioned tomorrow.
No,
We-
let it appear today.
Very
Okay.
well.
My
as
lord,
per
my
your
lord,
lordship.
my lord.
You're for?
I'm for the defendant, my lord.
Learned
Yes.
friend is for the
Great. 2 p.m. in the list.
My lord.
2 p.m. Great.
To be mentioned, item number 2, Bhagya Lakshmi Engineering and Fabrication Private Limited.
My lord, I appear, my lord, for the petitioner in both the connected matters. My lord, it's for
I do appear for the judgment debtor in both the matters.
my lord. Today, my lord, it's appearing for extension of interim order. The interim order is expiring tomorrow. It was last extended by my lord on 7th May 2025. May I request my colleague to hand over a copy? This is my lord. The determination is with my lord Justice Mojumdar. My lord has the urgent determination.
So the interim order will expire when? 22nd.
Tomorrow, my lord. Tomorrow, my lord will see my lord's last order of 7th May 2025. That is the last order of extension.
Yes. Recorded note.
Yes.
You're for?
I'm for the petition.
Petitioner degree holder.
Yes, my lord.
But I do appear for the judgment debtor.
Learned advocate for the petitioner degree holder and learned advocate for the judgment debtor are present. As the interim order passed earlier is going to expire on 22nd May 2025. The same is extended till 1 week after vacation.
My lord will give a slightly longer date. My lord, we are unsure when that court may be available again. That's why.
Mention again.
Great.
Great, my lord.
Item number 4, Hanuman Prasad Bakri and others.
For the plaintiff.
In this matter, my lord,
Yes.
I have been appointed the commissioner for the purpose of recording the evidence of the plaintiff witness. My lord, the evidence has been taken, my lord. There were 14 sittings. The report is ready along with all the men.
Plaintiff, that is PW1.
Yes, my lord. PW. Only that was the only witness that was examined and that was to be recorded. My lord, may I file the report?
Yes, yes, yes.
And my lord, may I give a copy
You
to
are for the plaintiff.
So one thing I have to point out, my lord, initially the defendants are appearing. After that, they have not appeared.
No, they have filed written statement.
Fully released.
The suit is not appearing as undefended suit
No, no.
Till now.
till now.
But they have not appeared, my lord, even in the
So
issues framed.
issues are framed, witness action has started.
Sir, started only as a complete date.
Was there any cross-examination from the
No,
side?
my lord, they before the stage for cross-examination commenced, my lord, they left midway. However, my lord, to keep all the records proper, all the minutes, the soft copies of all the minutes have been served upon them at their known email address. So all the minutes have been served upon them. They know as to what the situation has been.
Yes.
And my lord, may I file a report, the
Yes,
copy of the report to the plaintiff?
Mr. Ghosh, learned commissioner, appointed in this suit to record the deposition of plaintiff witness number 1 is present. Stop. Learned commissioner files his report. Let the same be kept with the record. And copy is already served upon the plaintiff. The same may be served upon the defendants.
We do not know, my lord. They are not
No,
appearing. The
was-
advocate and record is also not appearing.
No, but he's in the record. You
So, my
said
lord, the advocate and record, my lord, the mail, soft copies are being sent to the mail through email. The advocate and-
that has been sent, soft copies.
Yes, all the minutes, not the report. The report I have not, because my lord, we do not know whom to send. The advocate.
The advocate on record is there in the record. You
No,
can send him a notice to collect it from you.
He has said that she is no longer appearing.
Oh.
The records are all there, and I've stated that in the report.
So, commissioner can be discharged.
Yes.
Learned commissioner is discharged. How much initial remuneration was paid?
This is the last order.
Okay. Let a further remuneration of 1500 GMs be paid to the learned commissioner. Stop. Let this matter appear on 25/6/2025 at 3 p.m. for witness action.
No witness, I don't know. We have no witness, my lord. Another witness.
Anyway, let it appear. If you don't want to adduce, it will be fixed for arguments.
Yes, yes, my lord. Yes.
Your lordship will be pleased to record only one thing, my lord.
Yes.
The report along with all the minutes and documents that I had. My lord, everything is there in the envelope, along with all the minutes and the documents.
Let the report along with the minutes filed by the learned commissioner, copy of which is already served upon the plaintiff's advocate, be kept with the record.
Deeply obliged. I'm deeply obliged.
Item number 5, in the goods of
My lord,
Gopinath
I
Banerjee.
appear for the petitioner. My lord, item number 5 to 10 are all connected matters. My lord, different properties, one testator. Now, my lord, the difficulty is only in item number 9, the executor has died. We have already taken
you
out
are
the
representing the executor in all these matters.
all these matters.
5, 6, 7, 8, 9.
Yes, 5, 6, 7, 8, and 10, where the application for the discharge of the caveat has already been allowed, my lord, and ready for grant of the probate. Only in case of item number 9, we have taken out an amendment application which was allowed because in the will, my lord, there was a provision: if the executor dies, the wife of the executor shall stand in. That amendment has been allowed. Now, the difficulty is the amendment has taken place. Now there should be an advertisement on the fair ground only in respect of item number 9.
What is to be, what orders are to be passed? This 5, 6, 7, 8.
My lord, 5, 6, 7, 8 and 10, my lord, the discharge of the caveat has already taken place. Now, my lord has to formally, my lord, allow the probate application.
So let it be fixed for argument. You are representing the executor in all the cases.
Nobody is appearing for the
Let
other
it
side.
appear for arguments,
Very well.
provocation.
Very well. No, it is non-contentious cause, my lord.
But it is arguments can be for contentious, non-contentious, all the matters.
Then, my lord, let
To
it
argue the
appear.
matter.
Then, my lord, in that case, my lord, what felt from your lordship, let it appear for final disposal.
Yes, arguments, the matter can be disposed on that day or after a few days, the order can be passed, either way. But you make you, anyway, for arguments and disposal.
For final disposal, I suppose, because there is no other side, nobody is there. Formally, it's in solemn form, my lord, and Formally, the caveat has been discharged.
Undefended suits and ex parte suits, after the evidences are adduced, usually one date is fixed for arguments. Okay.
My lord, probably, my lord,
Abundant
if-
caution.
my lord, in my respectful submission, my lord, if the caveat have been lodged, my lord, then it could have been transformed into the testamentary suit. Now here, my lord, the caveat has been discharged.
Yes.
So it will remain as PLA. So it
that-
has to be
So that case has to be heard out. Arguments have to be made by
very
you.
well, my lord.
Yes.
In that case, my lord, only in respect of item number 9, my lord, may I
Yes,
publicly
yes, I'm just recording.
I can come back, my lord.
Yes, item number 5, 6, 7, 8 আর 10 ঠিক আছে 9টা বাদে the learned advocate for the petitioner executor is present. Learned advocate submits that the caveator is discharged and the evidences, the witness actions are complete. So
No requirement for witness
there is
action.
witnesses are not examined in this
My
case.
lord, there is no requirement, my lord, because
No, you see how the document will be exhibited if testator's signature is not exhibited. The attesting witnesses should depose. No,
my lord,
if you see,
my lord, in my respectful submission, my lord, in the practice that we do, my lord, here, my lord, if it is in the solemn form, my lord, the probate has to
whatever
be.
it is, you see, it should be examined.
Because the affidavit of the witness is already on record, my
So
lord.
let you examine him. I'm just fixing a date. You examine all these witnesses. Let the signatures be exhibited. Signature of the witnesses be exhibited. Anyway, I'm fixing a date for examination.
My lord, perhaps the original side rules that does
No,
not.
there are other matters also. I have
Very well,
examined
my
the
lord.
witnesses.
Kindly keeps it, my lord.
No, to কেটে দিন. When shall I keep it?
My lord, let me just come back on the publication for item number 9 so that the whole matter can come back. So kindly keeps it 3 weeks after vacation. Publication হয়ে যাবে? 3 weeks after
Okay,
vacation.
just let these matters appear under same heading or for
For
witness.
final disposal, my lord.
No. This first of all, this evidence. At least bring some attesting witnesses.
Non-contentious, my lord,
It's a matter of probate. Okay,
my lord, I'll come back, my lord.
Let
Kindly
this
keep it
matter
3 weeks.
appear on 24/6/2025
Very well. Kindly keeps.
for witness action and disposal.
For final disposal. Witness action and
final disposal. হ্যাঁ caveator discharge ওটা থাকবে আর কি. Yes, item number 9.
Item number 9, my lord, also may come back because in the meantime, we'll do the publication. It can also come back for final disposal.
Okay, learned advocate, item number learned advocate for the petitioner executor is present. Learned advocate submits that publication is to be made. Final publication is to be made. Let the same be done. Let this matter appear on 24/6/2025. Same date হয়েছে তো 24/6. Okay.
Grateful.
একসাথে আর এই 9টা
And my lord,
ইয়েতে থাকবে to be mentioned.
in respect of item number 9, kindly there be a direction for publication in one of the newspapers in English and
Item
Bengali.
let the publication be done in one English, one Bengali, and one Hindi.
Hindi not required.
One
Bengali
English and one Bengali newspaper. Circulated in the widely circulated in the locality where the deceased
Suit
last
property is
resided.
located, my lord.
Where the suit property is located.
Grateful, Lord.
Item number 11.
My lord, this has settled. My lord, I am filing the terms of settlement, my lord. The suit for specific performance. As per these terms of settlement, my lord, there will be a decree for specific performance. Only sale consideration has enhanced. If your lordship kindly come to my lord, page 2, para 1. This is the settlement.
Signed by all the parties.
Yes, signed by all the parties.
You are for all the plaintiffs.
My lord, I am for the both. I am appearing for the plaintiffs.
I appear for defendant number 1 and 2.
1 and 2. How many? Only there are two defendants.
No, there are three defendants, my lord. The defendant number 3 is the pro forma defendant.
Yes.
Against them, we have no prayer for specific performance even.
No reliefs were claimed against the three,
No
only
relief
against
was
one.
claim against 3.
So decree in accordance with the terms of settlement.
Terms of settlement.
Yes, record an order. Learned advocate for the plaintiffs and learned advocate for the defendant number 1, 2, 3. No, 1 and 2.
Plaintiff number 1 and 2.
No, defendant number
1 and 2.
1 and 2 are present. It is submitted by the learned advocates for the plaintiff and defendant number 1 and 2 that the parties have settled their dispute and have accordingly filed the terms of settlement. It is further submitted that no relief is sought for against defendant number 3,
yes,
which is a pro forma defendant. Thus, no relief is being granted with regard to defendant number 3. Let there be, thus this CS number 303 of 2012 be disposed of in accordance with the terms of settlement. Let the terms of settlement be a part of the decree.
Yes, my lord, be decreed. My lord, he has said
Yes, the
disposed
suit
of.
Instead of
decreed.
disposed of.
Instead
The
of
suit is this decree disposed and decreed
Yes,
in terms of, in accordance with the terms of settlement entered into between the plaintiffs number 1 and 2 and defendant number 1 and 2 on 20th day of May 2025. Between plaintiffs number 1 and 2 and defendant number 1 and 2 on 20th day of May 2025. The connecting GA applications
Yes, all
also
applications stands disposed of. Grateful, man.
Very good.
My lord, I am led by Mr.
Lord, could the decree be drawn up expeditiously, my lord? Your lordship.
The decree may be drawn up expeditiously.
I'm very grateful.
Item number 12 in the goods.
My lord, it has come at my instance. My lord, this is a probate application which is yet not become contentious. My lord, although to be on the safe side, I have given notice to the caveator. My lord, I wish to, my lord, my client has given a notice. My lord, he is not able to, my lord, continue. He wishes to withdraw the probate application.
The petitioner executor.
Executor, my lord.
So we are the respondent, number 1 and 2. We are appearing on behalf of the. We have no objection in respect of that. The application is.
You are also a beneficiary.
I'm the beneficiary and I am the executor.
Yes, record an order.
Actually, I am a third party. I'm not the normal line of succession, my lord.
No, you are the executor and
Yes, executor and the beneficiary of one of the properties of the deceased.
Mr. Ghosh, appearing for the petitioner executor, is present. It is submitted by Mr. Ghosh that his client is not willing to proceed with this application for the reason stated in the notice dated 9th May 2025, addressed to the learned advocate and advocate on record for the petitioner. Upon perusing the notice and upon hearing this, the learned advocates, this court is of the view that the prayer should be allowed. Thus, ELA number 103 of 2020 is dismissed on the ground of non-prosecution.
Along with all other applications.
The other applications also stands disposed.
So deeply. And copy of that letter be
Let
kept
the
in
copy of the letter addressed to the learned advocate by the petitioner executor be kept with the record.
Sorry.
So much.
Your Lordship, I'm appearing on behalf of the petitioner. It's coming in our instance, Your Lordship. The parties have reached in settlement. Your Lordship, I wish to file the terms of settlement. Let the suit be decreed in terms of the settlement agreement, Your Lordship.
You are for the plaintiff.
Yes, Your Lordship, I'm
You
for
are
the
for the
plaintiff.
defendant. Only one defendant.
Sole Signed by both the parties.
Yes, Your
Your
Lordship.
Lordship.
Internal page 5, Your Lordship.
Yes, record an order. Learned advocates for the plaintiff and learned advocate for the defendant are present. It is submitted by the learned advocate that the parties have settled their dispute outside court. This is 111 of, okay, 111 of 2022.
Your Lordship, it was mentioned it was the determination of Justice Mojumdar.
This is an old
The determination of Justice Mojumdar.
No, it is CS 119.
111.
But it is mentioned 119. Huh? Oh. The 119 is it is submitted by the learned advocates that the parties have settled their dispute outside court and accordingly have filed the terms of settlement. Upon perusing the terms of settlement signed by both the plaintiff and the defendant, and upon hearing the learned advocates, this court is of the view that the prayer for passing decree in terms of the settlement should be allowed. Thus, this suit CS 119 of 2024, old number 111 of 2022, be disposed and decreed in accordance with the terms of settlement entered into between the parties on 21st day of May 2025.
Your Lordship, 6th May. Only that punching is of 21st May.
Yes.
The settlement is dated 6th May. Your Lordship may see page 5.
Page 5. No, where do I get 6th May?
Your Lordship, my learned friends have.
You see?
Very well, Your Lordship. Very well.
Okay. Let a decree be drawn up in accordance with the terms of settlement.
Your Lordship, interim orders, if any, may be vacated.
Okay. The interim orders, if any, stands vacated, and connecting G applications, if any, also stands disposed.
Great.
Grateful, Your Lordship.
Motions item number 14. Srimati Shaili Ghosh.
But not today.
15. Madhavendu Kundu and others.
For the petitioner, my lord. I am the legal heirs of the plaintiff, number 3.
This is your application?
My application, my lord.
Yes.
The suit was for a declaration that the plaintiff are the Shevites of the deity's property, and that suit, along with other suit filed by the other side, analogously disposed of by terms of settlement. Page 33, my lord.
Yes.
Page 33. For administration of the Devotha properties for framing of scheme for effectively carrying out the daily Sheba and periodical festivals of the defendants, Sri Shri Radha Krishna Jiu Thakur, for possession of the Devotha properties for appointment of receiver for accounts for removal of the defendants Indra Kumar Das and Sholendra Kumar Das from Shebaitship for execution of the defendant Sholendra Kumar Das from portion of 21 Kanaidhar Lane for men's profits by the defendants. May I, page 36, may I straight come to page 36, terms of settlement, madam. By consent, it is agreed that the suit be declared in terms of the following terms of the settlement. It is declared that the plaintiffs number 1, 2, and 3 are declared as Shebaites of the deities C.C. Ishwar Radhakrishnan Dev Thakur, the defendant number 3, herein as heirs of Narendranath Kundu, deceased. The plaintiffs and the defendants number 1 and 2 shall all participate in the Sheba Puja of the defendant number 3 DT and administer the Devotar estate as Shebaite in terms of the deed of endowment dated October 15, 1931 of Biharilal Das, deceased in the manner following. A, the defendant numbers 1 and 2, Indra Kumar Das and Sholendra Kumar Das, will act as the Shebaites for a periodic terms of Pala of 1 year each, and the plaintiffs jointly will act as the Shebaiteships for a periodic term of Pala of 1 year. During the term for which the plaintiffs will act as Shebaites, the plaintiff number 1, Madhavendra Kundu, will be entitled to represent his brothers, the other 2 plaintiffs herein, and act on their behalf. During the term or Pala of Shebaiteship, as aforesaid, the respective Shebaites shall perform the Sheba Puja of the said deity, collect rents, effect necessary repairs, pay necessary taxes, make disbursements, and otherwise administer the Devotar estate in terms of the said deed of endowment dated October 15, 1931, and during the continuance of the term or Pala of one Shebite or group of Shebites, as aforesaid, the other Shebites shall not interfere with the administration of the Devotar estate. In case the differences of opinion, the wish of the majority of the acting Shebites, as in clause 2 within bracket A, hereof will prevail. All rent bills relating to the aforesaid Devotar estate during all terms or palas as aforesaid shall be signed jointly by Indra Kumar Das, Sholendra Kumar Das, and Madhavendra Kundu, and rent will be realized by issuing rent bills so signed. The respective Shebites shall facilitate the signing of such bills. The collection of rent for each month shall be deposited in a scheduled bank in the names of the Shebites as mentioned in clause 2A thereof. Such banking account shall be operated by any 2 of the Shebites as mentioned in clause 2A hereof. In case of death of either Indra Kumar Das or Sholendra Kumar Das, their respective heirs, along with the survivor of either of them, shall be jointly entitled to perform the Sheba Puja of the said deity, collect rents, effect necessary repairs, pay necessary taxes, make necessary disbursements, and otherwise administer the Devotar estate as aforesaid for periodic term or Pala of 1 year, and the plaintiff shall perform the Sheba Puja of the said deity, collect rents, effect necessary repairs, pay necessary taxes and other dues, make necessary disbursement, and otherwise administer the Devotar estate for a term or Pala of 1 year. In case of differences of opinion amongst the said Shebites, the opinion of the senior of each group will prevail. The defendant number 4 herein, being the receiver, Mr. S.K. Roy Chaudhuri, if bar at law, shall continue to act as such receiver until further order of court, during which time he shall collect all area rents, pay up all taxes and other dues, and pay up the tax cost of the respective solicitors of the suit and of that suit of 1760 of 1964 of the Honorable Court out of the funds of the head. That suit 1760 was filed by them, and our suit is 559 of 1967. Both suits were agreed amicably by virtue of settlement.
This one order, 1 degree.
1 degree. And my lord, the applicants, the legal heirs of the plaintiff number 3, plaintiff number 1 and 2 died, and seeking for an order be empowered to act as step along with the other parties.
Okay. Plaintiff number 2 died.
Plaintiff number 2 died, and one also died.
One
One
also
also
died.
died. His wife also died.
Plaintiff number 1 and 2.
2.
So at present, who are discharging this?
At present, Rabindranath Kundu, Rabindranath Kundu, the plaintiff number 3 also died, and the legal heirs of Rabindranath Kundu.
Okay. So plaintiff number 1, that is Madhavendu Kundu, plaintiff number 2, Ashok Kumar Kundu. Both of them died.
Both of them died.
And plaintiff number 3?
Plaintiff number 3 also died.
3 also died.
I'm the legal heirs of plaintiff number 3.
You are the legal heirs of plaintiff number 3. That is Srimati Bharati Kundu and Taposh Kundu.
Yes, sir. Taposh Kundu and Bharati Kundu. Wife and son.
So apart from you are praying to,
I am praying
to act as a trustee of the
Devotar estate.
Devotar estate. No, at present, who are administering the Devotar estate?
At present, my lord, at present, by virtue of order, I kindly see the Mr. Prosun Ghosh was initially appointed as official receiver.
Who?
Mr. Prosun Ghosh.
That is page?
Page 48.
Page 48. Yes, 47.
47. Passed by Honorable Justice Patharia Divyan was the official receiver is directed to furnish accounts to the Shevites within 6 weeks from the date of receipt of this order. In the meantime, I appoint Mr. Prosun Ghosh.
So
Mr. So far,
this
my
was abated. This suit was abated as per the order. Abatement of the instant should be recorded. So far, this was when? 2009.
2009. 15
So,
June 2009.
if there is an order recording the abatement, so this has to be set aside. There is an order. This is 1964, and your is this suit?
My suit is 559 of 1967.
Yes, 1967. But according to you, both the suits were disposed and decreed by a common decree.
Common decree.
That is annexure.
That is page 31.
That is page 31.
31.
31. That is, yes, 31. No, 31, what we find that speaks about 1967 suit, page 31. 1967.
Yes, that is my suit, 559 of 1967.
Yes, this is the terms of settlement.
Terms of
Yes, by virtue, this is 1760 of is settled.
Settled. That 1760 is filed by them, filed by the Sholendra Kumar Das and others.
So these same terms will apply.
Same terms will apply of both properties, over the both properties.
Dear my lord, CS number 1760 of 1994. This is the shoot of my predecessors. I am now.
1964.
Yes. at page 47 in their application. Next step D.
47. Yes.
This is my lord. I am appearing here on behalf of Shailendra Kumar Das heirs. We are the grandson and daughters of Shailendra Kumar Das.
Because you see, there is an order. You see, 15 June 2009 that was awaited. This 1964 has awaited, although there is no mention of this 1967 suit. This is yes. What do you say about this application?
I have to file my affidavit in regard to these applications because only the copy has been served upon the Shailendra Kumar Das legal heirs. We are the party here. So other respondents are not appearing because there are other and the as per the paragraph number 18 of their applications.
Yes.
Yes, the names and the address are not correct in regard to the other legal heirs because all of them are not residing in the same subject premises. I am for the Arati Das, Jhumki Das, and Shondip Das, who are the legal heirs of Shailendra Kumar Das.
So all are legal heirs. This
All are
one,
the
two,
legal heirs.
1, 2, 3, 4.
Yes, Shailendra Kumar Das has two sons. One is Topon Das and Shopon Das. We are the wife, daughter, and son of Shopon Das. Shailendra Kumar Das is our grandfather.
So you file your affidavit?
Yes, affidavit. Yes.
Yes. Learned advocate for the applicants. Presenting the representative applicants being the heirs of the deceased plaintiff number 3, Robindranath Kundu, is present and moves this application GA2 of 2024 with a prayer to be appointed as joint trustees. Of the Devottar estate. Learned advocate appearing for some of the legal heirs of Shailendra. Yes, what was the name?
Shailendranath Das.
Of Shailendranath Das.
Defendant number 2 hearing.
Defendant number 2 since deceased.
Since deceased.
Herein is also present and prays for leave to file affidavit in opposition.
But here
Thus, affidavit in opposition.
My lord, the one correction, my lord, Shailendra Kumar Das. It is not Nath. Because in the cost title it is written Shailendra Nath. This is wrong.
Let affidavit in opposition be filed by 13/6/2025. Reply, if any, by 20/6/2025. Let this matter appear on 26/6/2025. Necessary correction in the cost title may be made.
And in regard to, my lord, paragraph number 18.
Yes,
also,
and
because
service be effected upon the other surviving legal heirs of deceased defendant number 1, Indra Kumar Das, and deceased defendant number 2, Shailendra Kumar Das.
In the meantime, I have already served the notice upon the legal heirs of the Indra Kumar Das also, but that all are
So file it on the. You take further steps in the meantime.
Because my lord, paragraph number 18, this is wrongly written. It's not correct.
Then my
Yeah,
liberty to
and
liberty to
Oh, I've given you liberty to correct the cost title.
cut the cost rate and also liberty to further service upon the correct address if I ascertain, my lord.
Achha.
And also, my lord, we are the
Liberty is
legal heirs
granted
of
to cause further service upon the legal heirs of Shailendra Kumar
Indra Kumar.
Indra Kumar Das.
Shailendra Kumar Das, we are the sole legal heirs.
Yes, Indra Kumar
Yes,
Das.
we are the sole legal heirs in regard to Shailendra Kumar Das.
Yes, cause service and then come and file affidavits also in the meantime.
Next day, returnable date. Date two. Appearance date.
Not only one.
But the fixed matter আছে.
Yes, not only one indulgence before the fixed matter. The next matter, my lord, I would be seeking a leave to file a supplementary affidavit.
Which case?
The next matter, item 16,
Matter, my lord,
where my learned senior friend had taken a point that beyond the pleadings, my lord, we had made the arguments with regard to Order 7 Rule 11. So, my lord, I was seeking your lordship's kind indulgence to file a supplementary affidavit today, subject to your lordship kindly granting the leave and serving a copy on the other side. They can come back.
to application school.
Okay, ready to.
Once I have taken the point that it cannot be done.
Your lordships allow Order 6 Rule 17 to be filed to amend the plaint. But to supplement my Order 7 Rule 11, this is not.
Not on that.
But it's only a point of law.
What I'm trying to say is, my learned friend probably didn't understand what I'm trying to say, is that if I take an application, if I have taken a point, and in defense to that, now you are trying to take away the point by doing anything. Like, Order 6 Rule 17 cannot be allowed once a defense has.
Whatever is necessary to adjudicate a dispute, that has to be allowed.
I'm not on that. As I said, once I have taken that point, that you cannot do this. I can understand, Milord, before my taking the point, he realizes that and he files a supplementary affidavit coming and say. When I have taken the point that these are things which are not there, he is now trying to take away. Suppose, Milord, that's the only defense I have.
Yes, record an order. Learned counsels for the parties are present. Mr. Gupta, learned advocate for the defendant petitioner, prays for leave to file the supplementary affidavit, which is objected to by Mr. Dotto, learned counsel for the plaintiff. However, in the interest of justice, as the question involves a point of law and was raised at the time of arguments, the supplementary affidavit may be filed. How soon can you file on the Rio?
No, it's ready.
File. Okay. Affidavit in opposition may be filed to the supplementary affidavit.
Without prejudice, including the question that it cannot be done.
Anyway, I've recorded your objection. The affidavit in opposition to the supplementary affidavit be filed by 13/6. Reply, if any, by 18/6. Let this matter appear on 23/6/2025.
We have already served a copy.
Yes.
Great.
If your lordship takes up the fixed matter, lordship will. Item 18 was very short application for disclosure of 2 documents before settlement of issues.
Oh, there is a fixed matter at 12:30.
There is a fixed matter. I will
come at 2.
2 p.m. also there is a fixed matter.
Come before that fixed matter.
No, item 18, what is the urgency?
No urgency. To be very honest, there is no urgency.
So try tomorrow.
Yes. Item number 19, my lord, is that matter where lordship, the modification of the decree has been sought. My lord, I was praying.
Oh, that commissioner's
Yes, my lord.
partition.
1 week after the vacation, my lord. Kindly keeps it 1 week after the vacation.
Okay, item number 19.
1 week after the vacation.
On the prayer of learned advocate, the matter stands adjourned till 13/6.
Yes.
2025.
Item 19, my lord.
19 নম্বর, হ্যাঁ?
Item number 17.
Yes, Mr.
My lord, just before my learned friend starts, my lord, your lordship had also, my lord, only because your lordship, my lord, raised a query on the last occasion, and my lord, I would must add, my lord, validly so, that whether there was any minutes. But your lordship recalls what the facts are.
Anyway, resolution minutes.
Is resolution. My lord, I've got the original resolutions. 3 resolutions in a row. First resolution, my lord, the matter comes up before the board of partners. They say
How
very-
many resolution copies are there?
Not only one of each. But my lord, all I'm saying is it is not that the decision was taken in one resolution. My lord, first the matter came up before the partners. Then they said, very well, this is the scenario. Let us talk to the
Now,
defendant.
question is, you want to use an affidavit to this resolution so that your learned senior friend can deal with that.
No, I will produce the documents in affidavit. My lord, now we are only on the question of interim order. My lord, I will obviously, your lordship, my lord, will pass an order of affidavit. I will include all that. But just to satisfy your lordship.
No, definitely. With regard to satisfaction, after perusing the affidavits, after hearing both of you, necessary decision will be taken. But if you want to use an affidavit, let me adjourn the matter. Let your learned senior friend go through that.
My lord, may I make myself clear? My lord, he has made an application asking for, my lord, stalling of the decree, asking for, my lord, the receiver not to, my lord, hand over the amounts.
Yes.
Now, my lord, he has also asked for interim orders in this regard. My lord, today we are only on the scope whether this interim order can be granted or not. My lord, affidavits will be granted.
No, otherwise, you see, if there is no interim orders, suppose entire thing is taken away, so what will be the position?
My lord, may I say this?
If it goes.
My lord, that's why I cited the judgment of Justice P.B. Mukherjee, which says that, my lord, even taking his case at the highest, that he was not consulted. My lord, and if it's a partner and a partnership firm, no question of all the partners, my lord, agreeing. And if the one partner does not agree to the compromise, the remedy lies in him filing a suit against all the partners. The decree cannot be set aside. Exact facts as ours. Neither the decree can be set aside.
I cannot come to a conclusion. You see, from the facts of the case, that the decree cannot be set aside or the decree should be set aside, because that I have to reserve it. So now, with regard to the documents, okay, with regard to the points of
But I've
law,
understood.
you have relied
Please,
upon the decision.
just give me one
Now you want to rely upon these resolutions. If you want to use an affidavit, give them a copy.
My lord, then, my lord, kindly allow us to file affidavits. I believe if I've read your lordship's mind
That is
correctly.
supplementary affidavit to you.
No, my lord. Now allow us a proper affidavit in
Yes, yes.
opposition.
No, opposition you have already, you have not yet.
No. So that is what I'm saying. I
So
was
it's better incorporate everything there.
Yes, let me incorporate, and if I am not wrong, I've read your lordship's mind. Your lordships will give some
So otherwise,
protection to
what
them.
is the use of complicating the matter? You will produce some documents, they will not rely upon it.
All I was saying, and it is permissible to me to show, even without affidavits, on the face of it, that this application does not merit an interim order. Because I know what is going through your lordship's mind. But my lord, all I'm saying is the law says his remedy is elsewhere. So, my lord, I am saying on that basis, on the basis of the judgment that I have cited, that his remedy is not to stall the decree. The decree has to go through.
Conduct of the parties definitely will be considered at the time of
Very well.
taking a
Then kindly allow me to
Immediately
file an
conduct of the
affidavit.
parties will be
Then, my lord,
considered.
kindly allow me the shortest possible affidavit.
So affidavit in also opposition, and if the learned advocates may decide, you can't come with a short notes of arguments also.
Will come, but give me the shortest possible time to file it because my decree is stuck up.
No, when you can file, you tell me after vacation.
With regard to the short notes, my lord, may we have the pleasure of writing, having the short notes after we get the affidavit in opposition, or else we would know how to deal with them.
They will serve you a copy, advance copy.
May we file within 10th of June?
Yes.
My lord, one indulgence. My lord, a supplementary affidavit is being filed incorporating only the partnership deed. I'm sure no one will. The partnership deed is not before my lord. The partnership deed, my lord. Yes, of course. Everyone will be served.
Yes.
My lord, this is
Learned
a
advocates for the
partnership deed.
parties are present. GA 11 of 2025 is taken up for consideration. Heard learned advocates, as this matter is required to be decided on affidavits, and the learned advocate appearing for the parties, opposite parties have prayed for leave to submit the affidavit. Leave is granted to file affidavit in opposition to this application by 10/6/2025. Reply, if any, by 16/6/2025. Let this matter appear on 18/6/2025. এই 18/6 এ দেখুন তো কোনো ফিক্সড আছে কিনা?
Yes, my lord. That would be will be highly obliged if your lordship fix. হবে entry model.
2 PM ও আছে, 3 PM ও আছে। 18/6 এ আর 12:30 কিছু আছে? 18/6 এ? Okay, 18/6/2025 at 12:30 PM.
As your lordship. In the meantime, my lord, the parties and receiver will not take any step.
Yes.
That last order is
In the
here.
meantime, the parties and the receiver shall not proceed further in this regard. Yes. That is already recorded on the earlier occasion.
Your lordship will be pleased to record that the petitioner has filed a supplementary affidavit,
Okay.
my lord, incorporating the partnership.
Leave is granted to file supplementary affidavit by the petitioner. Copy be served upon the learned advocate.
Copies have already been served.
If receiver has submitted his minutes, well, we'll do the needful with regards to
Yes, which one?
receiver. He has appeared, but he has submitted the report. He furnished the secure whatever what is the
Report filed in the department definitely has. Anyway, copies have been served upon you.
The law is very clear.
Yes, let it be a comprehensive application, argument.
To hearing by Mr. Ghosh, law is very clear.
So serve them an advance copy of affidavit in opposition so that written notes of arguments can be filed. The matter can be expedited.
We'll serve them the copy anyway on 10th. They will have to prepare the reply, so they will come to know what is there.
Yes.
We'll come with a tentative.
Ultimate sufferer is the defendant. I am out of money. I'm out of pocket, both in court and with them, and they are fighting. And
now, my lord, he is also saying that he'll sue us.
Anyway, you see.
We see what is happening.
You come with your written notes of arguments because the question of law, okay?
Yes, it's a question of law.
Mr. Shonendu Ghosh's client is also under an obligation to compensate me in terms of proceedings of the criminal court.
So
all Ghoshes are obligated to each other, it seems.
So in order to expedite the matter, come with the short notes.
Not to the bullet, my lord. একটা বললাম না not to.
কোনটা? 18th না না একজন মোশন তো 2 PM আছে একটা। হ্যাঁ 21
Motion item number 21, Anil Kumar Patodia, 21 to
My lord, item 18, my lord.
18 হয়ে গেছে। Yes, item 21, it will take some time, your matter. So, vacation.
Well, on the last day's order, I just trouble your lordship for 2 minutes. Well, kindly see the last day's order. So why are you giving me 23? Kindly have a look at the last day's order, my lord. Lordship के coordinator. Where is that? Last day's order? What are you giving me? There is no file.
No,
Sir,
I
kindly
was
take
hearing
the-
CA 16.
Yes, Mara. So
CA 16 I was hearing.
yes,
The
so-
plaintiff has made his
correct,
submission.
absolutely. Manoj, if your lordship sees the second paragraph, it is gone down as, however, there is no file with regard to GA 16. Up to.
Okay.
So this is possibly needs to be. GA 16 files are all there. And in fact, it was being heard by your lordship.
Anyway, all the
GA 16 files were there. GA 18 to 22 were not there. Last day.
18 to 22 has come.
Yes, it has now, Millard, it appears that it has come. Because no paper endorsements are not there in the list.
GA 16 will be hard after vacation. Because because before vacation it will not be concluded. Come after
Correct,
vacation.
correct. Very well. My lord, only one indulgence, my lord. Look, there is already a subsisting order. I just wish to point out to your lordship once. Kindly take the 27th of September order of 2013. And my lord, kindly take, this is a subsisting order in respect of a property which was with the respondent number 40. My lord, kindly take the last page of the order.
6.
My lord. Page 6, my lord, the second last paragraph, accordingly. In the event the respondent number 40 is desirous of selling its unit, the same be not affected except without the leave of court. So if they want to deal with it, all I'm saying is that kindly take the leave of the court and then deal.
No.
All that I'm saying.
No,
right
no,
now.
my lord, kindly don't, my lord, snatch order like this. My
Whatever-
lord, we are in the midst of the hearing.
Whatever order is there, that will remain. Okay. Because these orders are not modified.
No,
Yes,
this
whatever is there, kindly don't, my lord, allow him to snatch
in
order like
respect
this.
of defendant number
My lord,
40.
we are in the midst of hearing.
Similar orders in respect of
No. Kindly, my lord, don't allow this. Kindly don't allow this practice.
I've heard you see before vacation it cannot be disposed. So I'm telling him, please
Correct,
come after
absolutely,
vacation.
absolutely. I said that let this
No,
arrangement.
no.
They want,
No, not at all. Not
they
at
want
all.
to sell without the leave of the court.
Not at all. Not at all. You have not yet shown your locus.
This is
To any order being passed, my lord. I'm
this
ready
is
to
in
underway.
respect of defendant number 40.
We are ready to argue, Millet. We
A
are ready to
similar
argue.
arrangement be passed in respect of the other defendants.
No.
Very, very.
So
That's
sorry.
what I'm saying. If now your lordship will see, it will
My lord,
become an
nothing has happened
irreversible
for 2
situation.
years.
No, so then let them give the assurance that
Why
it will
should
not
I give an
happen.
assurance,
No,
my lord?
why?
Nothing will happen.
My learned
The
friend,
application is not maintainable.
I'm ready to argue.
Arre, you are the plaintiff. You have
It is my
included that in
prerogative
the
whether I want
property,
that order or not.
in the list of
Learned
your
advocates
properties.
In CS 338
Briefta দেবে কি কালকে মামলা হয়ে যাওয়ার পরে?
of 2013 are present.
ওকে দিয়ে দিচ্ছি।
Okay. It appears from record, that EA 16 of 2022 was taken up for hearing on the earlier dates, but the hearing could not be concluded. The hearing of this GA 16 of 2022 be adjourned till 11/6/2022.
Kindly, my lord, consider
Mr.
that. Yes, in
Mr.
terms.
Bush submit that the order passed by this court in another application 2980 of 2013 be passed with regard to his application, but the same will be considered after hearing the opposite parties, as the opposite parties have not concluded their submission. Moreover, the order dated 27th September 2013 passed by a learned judge of this court in GA 2980 of 2013 is not modified till today, and the same can continue.
No, that is in respect of defendant number 40.
Yes.
Yes.
With regard to
I am
defendant
saying
number
that
40.
same order be passed in respect
So
of
let them complete their
36,
submission.
37. Very,
I have also recorded that you have prayed for that order, and that will be considered after
very well.
completion of their submission.
11th of June, my lord.
11th of June.
So this is a confusion. When they say all the application, then they will come and say half of them are missing, files are not missing, files are not there.
No,
So
no,
16,
that
let
is-
16 be heard
At
separately.
present, I am hearing this application.
It is understood on 11th. I will argue, my lord, whatever happens.
Yes,
no
yes,
problem.
of course.
After you complete argument, he will
Yes, my
reply.
lord. Absolutely, my
And you may come with written notes of argument.
I
for
will,
those.
Absolutely, absolutely.
Yes, yes.
That is
On
required.
16. On GA16. Yes, yes. Other applications are not being heard. I am only considering GA16 on the grounds of urgency. Okay, the other applications.
Well, I'll tell you, Lord Shivala, this is
Other
creating the
applications
confusion.
shall also remain in the list.
No, let it remain in the list, but let it be understood that GS16 will be heard.
I have made it clear that I am hearing GA16.
Start হয়ে গেছে তো, hearing start হয়ে গেছে। Wait, oblige, my lord.
Testimony letters, item number 33, Jeevan Kishore Kundu.
My lord, I am for the petitioner, my lord. For the applicant, it's a pending application, my lord, since 2002.
So this is a non-contentious.
No, my lord, affidavit and my lord, affidavit and caveat in some, my lord, caveat and affidavit in support of caveat, my lord, both have been filed by one Niranjan Kundu.
So
Well, after that, my lord, no steps have
question
been.
is discovery and inspection has to be let the date.
Yes,
be
yes,
fixed
yes,
for-
my lord, it has to be converted, my lord, after the discovery inspection.
No, no,
Thereafter,
no. Let the date be fixed for framing of issues.
framing of issues, my lord. In the meantime, my lord,
Discovery and inspection be completed.
Yes, in the meantime, my lord, may I, my lord, serve a notice, my lord, on the caveator, since, my lord, since long, my lord, this matter has not been, my lord, listed or taken up, my lord. We have,
Okay, then let it appear after vacation.
after vacation, my lord, in the meantime, we'll serve, my
Learned
lord,
advocate
notice, and, my lord, for framing of issue,
For
my lord,
the
let the matter.
petitioner executed is present as none appears for the opposite party caveator, the matter stands adjourned till 11/6/2025. Learned advocate for the petitioner is requested to intimate the learned
My lord,
advocate.
directed, my lord. I have lordship directs.
For intimate the learned advocate for the opposite party caveator.
Opposite party caveat.
Yes.
My lord, only thing, my lord, your lordship will indicate, my lord, that the next day, my lord, for framing of issue, my lord, the matter would be posted.
Let him appear. Thereafter, in his presence, I shall pass that order.
So that, my lord, if any suggested issues, my lord, are to be filed, my lord, both sides can be, my lord, ready with the suggested issue on the next day itself, my lord.
Because they don't know.
My lord, the order will, my lord, the order along with notice, my lord,
The
also.
parties may file suggested issues on the said date, but discovery and inspection is not complete. How can you do that?
Yes, 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 my lord.
So it's
My
better let him appear.
Yes,
And
yes.
better complete all those things.
No.
Item number 34 is
11/6 না লাস্টটা দরকার নেই Yes, not today.
$35 in the boots of Kofi Chat Nahata.
Not today.
36 in the goods of Ashrafi in old suits item number.
Yes, item
My lord, I am for the defendant number 2B to 2D. My
In
lord,
37, in 37.
37, my lord.
36.
36.
Oh, you're 36 or 37?
37.
Oh, yes, 37.
37, my lord. I am for defendant number 2B to 2D. My matter is appearing today, my lord, for hearing of my application being GA 35 of 2024 for modification of the order dated 21st February 2023. My lord, wherein in this partition suit, there was an order of status quo to be maintained by all the parties to the partition. My lord, my share in one particular property, which is the subject matter of this partition suit, has been declared. Now, one of the co-sharer of that particular property.
For the plaintiff.
For the plaintiff, except plaintiff number 4 and 5.
Plaintiff number 4 and 5.
Except 4 and 5.
All other 1, 2, and 3.
Now, no one has filed any objection, my lord, despite repeated opportunity has been granted by my lord on 1st of May 2025, also by way of earlier peremptory direction passed on 29th November 2024.
You are for defendant number 2A and 2B.
2B to 2D, my lord. 2B, 2C, 2D. 2A has expired.
So,
I'm appearing for defendant number 9 to 14.
My lord, I
If
believe,
you want to contest this application, you have to file affidavit.
my lord, no one is, my lord, may kindly look into the order dated 29th February 2014, my lord, there was a peremptory direction.
No,
There are,
this is for 2024.
this is for
This is this application.
G,
Whether any opposition is filed to your application, GA35.
my lord, that opportunity was granted. No one has filed any objection, my lord.
Yes, 29 November.
29th November 2024, the matter had appeared before this honorable court, wherein, my lord, peremptory direction was once again given, my lord. And thereafter, matter had appeared before your lordship on 1st of May. Further opportunity was granted, no objection was filed. And further, my lord, there is no reason for filing any objection. The reason being is that this particular defendant number 9 to 14 has got no share in the property, which is the subject.
Are you opposing this application?
Affecting my rights.
Affecting their rights, my lord, because
regarding plaintiffs,
I'll just show, my lord, the order which I am seeking the modification.
yes, give me the record.
Yes, my lord. My lord will kindly take up
HGA, এটা দেখি 35.
21 है, हाँ.
হ্যাঁ लेकिन GA 35 টা আসেনি, ফাইল আসেনি. Okay, let the file come.
My lord. Lord, can it be kept at 2 p.m., my lord? We are waiting, my lord.
Let it be taken up after vacation, you see. But the file is not here, I don't know. But because last 2 days there will be different urgent matters.
My lord, only, my lord, the urgency is that the area which I am occupying, my lord, the defendant number 2B to 2D are residing at Mumbai, my lord. I'll try, my lord, if the file comes in the second half. But
Okay, let it be not today, just not today.
Lord, just
not
Lord, with leave of my senior, Lord, just one indulgence. Lord, let it be not today, but Lord, the right to file affidavit be closed, Lord.
Yes,
Otherwise,
yes.
Lord, tomorrow, my Lord.
No, they will
some
not
other
submit.
will come.
They will not submit with regard to affidavits.
No, my Lord, because there is a peremptory direction. Your Lordship's orders are not being abided by.
Tomorrow, your lordship will.
These learned advocates is going to appear tomorrow.
I hope, my Lord, they don't take time to file affidavits on the next day.
Not taking time today also.
So that be recorded, my lord.
So,
That be,
let that be recorded. my
এই
Lord.
ফাইলটাকে একটু আনিয়ে নেবেন, ঠিক আছে?
Let that be
আমি
recorded.
হ্যাঁ টেস্ট করতে পারছে না. Anyway, record an order. Learned advocates for the parties are present. Although GA 35 of 2024 is to be taken up for consideration, but the records are not here. Thus, the register original site is requested to cause an inspection with regard to the availability of record GA 35 of 2024 and submit a report on or before 10/6/2024. Let this matter appear on 11/6/2024.
I'm grateful. Lord, their submissions be recorded, my Lord.
The file is not traced out. Anyway, I've directed to cause an inquiry and submit a report.
my matter returnable date on
11/6.
11/6. Great. क्या करें बताओ कराइए
नहीं चलिए, कोई बात नहीं. Next time. Today I'll move.
Ashim Kumar Dhar and others.
My Lord, Ashim Kumar Dhar in this matter, my Lord, we have been running, my Lord, from time to time, my Lord. There are
You are the
two
plaintiff.
applications. I am the defendant number 7B. My Lord, before, my Lord, anyone says anything, my Lord, there are two applications, your Lordships, in the list. GA 11, my Lord, and my Lord, there is a new application called GA 19. My Lord, what has happened, my Lord, in these two matters, my Lord, we both are, my Lord, we want to sell our property, my Lord. In the partition suit, my Lord, preliminary decree passed. Our area has been demarcated. Now,
How many parties are there?
there are, my Lord, various parties,
About 20.
but only few of, my Lord, only few of them are appearing, my Lord. Your Lordship's last direction was to issue notice upon the interested parties, my Lord. That we have done.
But you see, if it is an impartable estate, okay.
Yes,
You see, there is one thing is this, that if the commissioner says that it is impartable estate and that report is accepted as final, then there is no other option but to sell that property. But if parties amicably agree to sell the property, but two parties are not agreeing,
Yes, that
then
is
the matter has to be decided.
My Lord, Your Lordship, my lord, we have passed that stage my lord, subject to correction. There has been an earlier order, my lord, by Honorable Justice I.P. Mukherjee when he was sitting singly, my lord. These kind of situations, my lord, on these kind of same cause of actions, my lord, applications were filed and applications were allowed also. Today, my lord, I am the other party who wants to sell the area, my lord, to an interested buyer. That is
Your share.
my share.
You see, part of the demarcation is not yet
But
complete.
he is interested in buying the whole of the property.
This is a completely demarcated number.
No,
Five
question is,
Shinara Dasland.
commissioner has demarcated the area.
This is absolutely different property. There are several other properties. 2, 3, 4
No,
properties.
no, entire thing, partition of the suit property. If the suit property comprises of several properties, then the demarcation of each and every property is to be done.
Demarcation, my lord, has not happened. My lord, the area in which, my lord, respective parties are residing, they wish to sell that part, which, my lord, was allowed on the earlier occasions, my lord, by this honorable court only, my lord, upon an application. That is why we have come up with an application.
This is fully
But
fully
in this
tenanted
particular
premises.
case,
In this particular case, in this
where is that order? Let me see.
This is a fully tenanted place, my lord. Parties are not residing there. None of the parties.
No, I'm defending number 11 in this.
Where is your advocate? You are appearing through advocate or in person?
In person, lord.
Okay.
We are the only intending purchasers, and the property has been valued. Everything has been done.
No, no, you are the purchaser. You want to purchase the other shares.
Yes.
Shares of
Even the valuation has been done.
1990.
That is a
no, no.
63
Question
lakhs has
is
been assessed by the
whether
High
all
Court.
the parties have agreed.
No, no, we are not.
No, they have agreed.
Lord, I'm just handing over a copy. I'm told, my lord, that your lordship is not having the GA. This is an order, my lord, earlier passed by Justice I.P. Mukherjee on the same cause of action application. Now, today,
no, you have agreed to sell a particular property.
I have agreed to sell a particular portion, but
No,
my
no,
buyer
full
wishes
stand.
to buy the entire
particular property.
Food properties may be located at different areas.
Yes.
But if you want to sell the property of a particular area,
yes.
Suppose that
Yes,
Paligan
my lord, I
Circular
get
Road has food property.
Yes, my lord.
Another maybe at Kosba, whatever it is.
Yes, my
So if that property, if you are willing to sell, whether
It
you
is
have
such a
come.
property. It is such a property, it is completely different property. There are several other properties. Some of the properties have already
This
been
application
sold.
is concerning.
Some of the properties have already been
How
sold.
many parties
This property, 5 Seed
you are
Nagar.
ready and willing to buy the shares of all?
Yes, yes. That has been.
But that has to be at the market value. It cannot be at a throwaway price.
No, it's not a throwaway. It has been
So
valued.
that has to be, you see, that has to be agreed by between the parties.
Lord, may I suggest one thing, Lord?
They want
Lord,
to sell that
Lord, I appear for the plaintiff. Lord, according to me, Lord, the best thing would be if the intending purchasers, there may be an auction in court.
Yes.
Who will give the highest price? Lordship
There
will
is a
allow.
commissioner appointed, receiver appointed.
Receiver is there.
This is a family partition suit.
Why don't you settle it between
I am
yourselves?
also a family member.
Why don't you settle
They
it?
have come in late. They have come in late.
So if you have failed to settle it outside court, then necessary orders are to be passed.
It has been settled in the court.
Lordship,
so come with a
No
settlement.
settlement.
Terms of
Lord, there is no
settlement.
settlement.
What is the terms of settlement?
that
There's no
will never be done. Lord, this is a suit of 1989. Till date,
Lord,
parties
if
have
one
not-
person,
Opportunity has been given to all the parties.
Have you entered into a terms of settlement?
No.
Then there's no
Lord,
question
if
of.
one person wishes to sell his portion, I don't know, Lord, what can stop him?
Lord,
Subject to getting the higher price.
Wanted to exercise a right of preemption. Then for that, the valuation was to be done. That valuation has been done by the
Report
High
to the
Court.
special officer.
There
That
are-
has been settled. And it is agreed that we are the only intending purchasers.
No.
Defendant level.
Where is that order? Where is that order? That you are the intending purchaser.
He has never, my lord, offered to purchase.
Lord, since there are disputes regarding purchase, there are some of the purchasers. It would be best by your lordship to pass an order directing all the parties to come in court and
And
give a-
let the bid be opened in
and
presence
bid-
of the
and
parties.
Now,
I-
first of all,
maybe either in a sealed envelope, maybe.
The bid be opened in presence of the parties.
And the highest bidder
sale
will
has
get
to be
it.
by the special officer.
Not a bid,
Uh,
this is a
space-
question of
the-
valuation.
the receiver is there. Some-
The
Yes.
property
receiver.
has been valued by the High
Sale has
Court.
to be by the special officer.
Now they want to bring in outside parties. This is a family matter and it is to be settled. It has been settled.
Then he
That
should
we-
buy it at the prevailing market
No,
rate.
If
He
you are
should buy
ready
it.
and willing to purchase it, you have a
Exactly.
discussion with them. At what price you are ready and willing.
It has been valued by the High Court.
Yes, is it valued?
Yes, in the
Lord-
year 2013, the order, the valuation has been submitted in 2015, and now it is 2025.
Now may I say, Milord? Milord, a land in the year 2013 is valued 100. Now we are in 2025. Can someone, Milord, sell a property which was valued 100 in 2013 in 2025? If everybody wants to sell, Milord, let a bid be happened in presence of the receiver, and the receiver will open the bid in
That would
presence
be
of
the
the
best,
parties.
that would be the best possible
Okay,
way.
how many parties are there at
About
present?
20, my lord.
But Milord, most
You
of
are
them are not.
representing the
No,
plaintiffs.
I'm for the plaintiffs, plaintiffs.
You are plaintiffs. You are for? Yes.
I am for 7B, Milord.
7?
B.
I am for the applicant in GA number 19 of 2020.
That application which my lord is seeing, Milord, that is my brief.
I have made an application. I have proposed an offer, my lord, subject to consideration of the court.
You are intending purchaser.
Intending.
He is not a party to the partition suit. He is an applicant. Whereas I am a party.
purchaser.
Whereas I am a Milord, party to the partition suit.
So have you held discussions with the parties?
My lord, we have sent representation to the receiver.
Anyway, so I'm adjourning the matter. Hold discussions with the parties.
Your
My lord,
Lordship,
that's, my lord,
that stage
thing,
has passed.
that thing will never happen.
Yes, Milord. That
thing will never happen.
You are the intending purchaser.
yes.
The intending.
Lord, I am
Right, my
also.
lord, that impasse will
Regarding valuation, okay, if all the parties agree with regard to valuation,
my lord, a report of valuation,
Lord-
my lord, was sought for by this court.
question is there must be a proposal from your side at what value you want to purchase.
He has proposed. He has
in our
proposed.
application, my
So
lord.
have I. We both have proposed. But Milord, time and again the applications are not being Milord, taken up, Milord, for some reason or
We
the
have
other.
not received your affidavit till date.
You have served
My application,
They
you
have
have
not
to file an
provided the
affidavit.
Of
Lord,
7B.
Someone
7
appearing
has
in person,
expired.
it's very tough.
7 has expired. 7's wife, 7A,
No,
had
no.
come into the picture. She has also.
Serve him a copy of the application.
Your Lordship, everything has been served, my Lord.
Already that captain.
My Lord, may kindly seize the
Yes,
earlier
yes,
order.
that-
Kindly see the earlier orders. Kindly see the earlier orders. My Lord, time and again this gentleman comes, my Lord, and every day he raises some or the other issue. We both.
That is not correct. I am one of the parties. I have right.
So am I. So am I. I am also one of the
No,
parties.
They have just come into the picture now. 7B, 7, their mother, their father, they had agreed to sell the property.
No, this is
Okay,
a,
but the thing is that in their affidavit, they had sought.
this
to
is a,
sell
What
their
is your GA number?
My GA number, GA11.
Okay, record an order. Learned advocate appearing for the plaintiffs. Learned advocate appearing for
Defendant number 7B.
7B.
I'm
You are for? You
I am
are?
defendant number 11.
Defendant number 11 in person are present in court. You are?
I am appearing for the intending purchaser. I have filed an
Learned
application
advocate
GA
for
19.
the
applicant in
intending
GA19.
intending purchaser who has filed an application GA
19.
of 2024.
19 of 2024 and defendant number, yes, 2 year
7B, my Lord. 7B.
7B have filed application being GA
11 of 2013.
11 of 2013. As the commissioner is already appointed in this case,
receiver, he is receiver.
receiver is already
The
appointed
nomenclature
in
is
this case,
receiver.
I adjourn this matter, granting, requesting the receiver to hold the discussions between the parties, including the intending purchaser, regarding the sale of the property, as well as to the intending purchaser or to any other party.
Lord, that will be, Lord, a
Okay.
futile exercise.
Upon discussion with the parties, learned receiver shall submit a report on or before 13/6/2025. Let a copy of this order be intimated to the learned receiver.
Lord, just
Make a point.
Just to add, my Lord, this exercise will be, my Lord, a futile exercise for the reason no one, my Lord, will agree, my Lord, and the report will be, my Lord, nothing. Your Lordship, I believe, my Lord, the plaintiff
Yes,
will
no,
agree.
nobody will sit.
Lord, nobody will sit.
Okay, I shall pass the necessary orders.
We have tried to
Milord,
do that.
Milord, Milord,
previously
make
also.
a
We have-
point.
we have
Your
given
Lordship,
the plaintiff
may
an-
kindly record purchasers because there will be someone else
No, no,
also, my Lord.
intending purchaser.
Purchasers.
Intending purchaser who is
Purchasers.
present.
Milord,
Yes, very well. my
Milord,
Lord.
the parties are interested.
No, you see, if the matter can be
Lord,
resolved.
I have a purchaser, my Lord, just to add, my Lord. I am, Lord, one of the parties in the partition suit. I have a purchaser who wishes to buy my share. In the alternative, he wishes to buy the entire of that property. Supposedly, my Lord, 5 Baligan Circular Road, for example. So, my lord, he should also be present, my lord. Otherwise, my lord, he will not be allowed to sit on that day.
We don't
My lord,
agree to that.
my lord, let that direction, my
Because
lord, come in.
it
My lord.
is a
Because
family-
my application, my lord, is for him only.
Anyway, is he offering any price for purchasing the property?
My lord, he should answer. He should answer.
No.
The
Did-
purchaser.
No. Did he offer any price? to
No,
purchase the
not yet,
property?
not yet, not yet.
No,
Or
we
He's
are
offering
got
a
the
price.
property valued by the High Court.
whatever you want to, whatever
may I submit,
price you
Milord?
want to purchase, you give me a letter to
May I-
these
may I
parties.
submit, Milord?
That is
Milord,
63
in
lakhs. We have
reply to
already
63
Third-
lakhs
third
was of
them a letter.
2013, not
our
acceptable.
application, they have filed their affidavit. In their affidavit, Milord, they are saying that the property concern is encumbered. They want the court to unencumber the property. They want the court to clear the title of the property.
That is
and
impossible,
Then they want
impossible.
to take a loan on that property, and
That is
that loan they want to purchase. This is their offer.
Anyway, I've made it clear, you please sit with the receiver.
Your lordship, may kindly
Their offer is
intending purchases, my lord.
Yes, intending
They should
purchase
not,
that.
my lord, stop my person, my lord. This is what I'm saying, my lord.
Yes,
Let's say a bid, highest bidder we can.
Intending
Actually, my lord,
purchasers
my lord,
and
the
to-
parties are interested only with the money.
This exercise could have been, my lord, shortened if your lordship may direct, my lord, everyone to submit their price so far as the property is concerned, my lord.
do
Then
that in your meeting with the receiver, okay?
very well, my
My
lord.
lord, the adjective
Do
30.
the needful.
30.
I shall do it. I shall.
It will appear.
13.
One more point.
Yes.
13, 6,
Defendant number 8 and 9 and 3, 4.
You see, unless you appoint an advocate, you are unable to represent your case. You better sit with the
But all
receiver,
the
no
time,
discussion.
he is making the difficulties.
You
All the
better appoint an
all
advocate, otherwise it is very difficult
Someone
to hear
appearing in
from
person, my lord, very
you.
tough.
You are totally confused. You are unable to clarify your case. Better sit with the receiver. Let him sit with the receiver. Yes.
Why will I have a problem?
One
Let him
point
say.
was-
Collect the copy of the order, sit with the receiver and give some proposal, whatever you want to do.
Your
The
lord,
receiver will file the report.
just one line, my lord. On that day, my lord, let our applications be considered, my lord. My lord,
Yes,
whatever affidavits, not affidavits, let it be considered on that day.
yes, that's
Yes.
that is
Pursuant to the report of the learned receiver, the other applications may be taken into consideration.
Yes, my lord. Extremely grateful.
much.
Extremely grateful.
My lord, subject to my lord's kind sanction, may I go through the records of item number 37?
Item 37, yes.
Yes, my lord, may I please go through the records?
My lord, I mentioned the matter, my lord, in the morning. Your lordship, my lord, was
দুটো matter, দুটো আছে তো না? Yes, what's your matter?
my lord, the matter, my lord, is suit for delivery upon cancellation, my lord.
No, is
There
it
was
CS
a-
195?
Yes, my lord. CS 195.
You are for the plaintiff.
I am for the plaintiff, my lord. My learned senior friend is for the.
Yes, when was the last order passed?
My lord, this is the last one. My lord, since my lord,
So it has expired long time ago. It's not
my
that
lord,
it will
since my
expire
lord,
today.
Justice
Yes,
Mujumdar, my
yes.
lord, is not in session, my lord.
Yes.
But since my lord, Justice Mujumdar, my lord, is not in session, my lord, I
No,
could not
question
take
is
place.
this matter is it's not that it is going to expire today or tomorrow.
My lord, I
It expired long time
mentioned
ago.
it before, my lord,
My
expired.
lord, let them make a formal application because this order has been extended on many occasions. The matter was heard.
Okay,
Let them-
after March 12, did this matter appear? After March 12?
Yes, it was
Mr.
appearing in the list.
Stop justice.
No. Any order is passed after March 12?
No.
I mentioned it before
It simply
expiring.
appeared in the list, but no order was
It
passed.
was appearing in the list.
It was not taken up in the
It
meantime.
was not taken up, but then they should have mentioned it before it expired. Or
I mentioned it
now
before
in the month of
expiring, my
May,
lord.
they're coming and now stay for extension
But
of
it
the
did
order.
not appear in the my lord list, my lord.
Let them make a formal application, Your Lordship.
Yes. Learned advocate for the plaintiff and learned advocate for the defendant are present.
I understand.
It is
Listen.
submitted by the learned advocate for the plaintiff
Listen.
that although the order dated March, although the interim order
Supplementary list.
passed on March 12, 2025, expired on 10th April 2025, but thereafter the matter was appearing in the list and could not be taken up. The learned advocate for the defendant objects to the extension of the interim order. However, in the interest of justice, this interim order granted earlier stands extended for a period of 1 week after vacation.
Grateful man.
কল না করে এবার কস্টের জন্য ভুল হয়ে যেত নামটা দিয়ে যাবে
Grateful.
Supplementary exchange for hearing item number 1 such food products
The
private
matter has come at my instance, Lord. Well,
Lord,
the
I am for the
interim
defense.
order was till today. Lord. Tomorrow,
Give
till
me the order.
Tomorrow, man.
Well, in all probabilities, court 40 will not sit with Justice Mojumdar.
Yes.
Justice Sugato Mojumdar's court, Willard, he is not sitting.
Where is this order?
Willard, last order, it was extended till 22nd of May 2022. I'll request Willard to extend it for a reasonable time after the vacation and keep the matter after 16th. Willard. Matter is assigned, he has to hear it, Willard.
Yes. You are for the defendant.
I'm for the defendant. Lordship will kindly keeps it 1 week after vacation.
Keeps it after 16th. My Mr. Bachawat is leading me. He's asked for 16th.
Learned advocate for the parties are present. Today was fixed for hearing of the matter.
No. Today was the interim order. Is till tomorrow.
So
So
it is
today I'm
appearing in
mentioning
the
he will
list.
not sit. Well.
Anyway, learned advocate submit on which GA?
Willard, GA number 1. GA number 2. GA 2. GA 2 and 3.
Submits on GA dash com 2 of 2024. Stop.
To the order as a 3.
It appears from order dated 7th May 2025 that the interim order which was granted earlier is going to expire
on 22nd. That's
on 22nd May 2025. Stop. The interim order stands extended for a period of 2 weeks after vacation.
2 weeks will not serve. Yes, 2 weeks.
2 weeks after vacation.
Yes.
Any date, Lordship makes it return.
I'm just making it 2 weeks after vacation because
date
that you mentioned before the.
Very well. I'll do that. Mention koro okhane. Grateful. Much obliged.
Grateful.
Adjourn motion. Item number 20, fixed at 2 p.m. AKR Consultants Private Limited.
Yes.
Please, Your Lordship.
They were to open their arguments.
We will open our arguments, and my lord, may I indicate? I'll have to take your lordship through the facts to indicate that this order 12 rule 6 petition, which has been moved by my learned friends, this is actually not maintainable. And through the facts, I'll indicate that they could not have moved this. But I will, at the very outset, try and narrate the facts as have been stated by my learned friends in their order 12 rule 6 petition.
So this is the application, that is GA 20 of 2024.
This is GA 20 of 2024.
So affidavits are complete also.
Affidavits are complete, but I have one difficulty since the last day when the matter was called. I was not there and the date was fixed today. It was not in my presence. The only difficulty is there's a fixed matter at 2:30. So I'm only praying. I'll start. It is not that
this matter cannot be completed before
it will not be
vacation also.
completed. But I'll indicate one fact which other than the merits, there are 3 points.
Around his personal ground yesterday, it was switched for day before yesterday.
Day
it was
before yesterday was because I was not there. So that was
they are
just for my
directly taxes.
I'm sure my learned friends.
This is a contested matter. It cannot be decided before vacation.
I'm very grateful. That's true. And my lord, kindly see.
6 months to file a
If my learned friend,
AO. 6 months, my lord. They are adopting dilated.
Lord, if he exhausts his energy, I will make 2 minutes submission.
Anyway,
One minute.
Anyway, affidavits are complete, so nothing more is required to be
Nothing
done.
more is required, and I'll indicate, my lord.
Has completed his
No, I have not made my submission. I have not even opened my case. I have only given an overview, and I'll tell your lordship what Mr. Thakkar has not told your lordship. They had made an application in this same matter where they had made a prayer for judgment upon admission. This they should have indicated to the Honorable Court. An application made with a prayer for judgment upon admission. The court, so there were 6 prayers. Prayer B was judgment upon admission, which they had prayed for. Against the original defendant number 5. We are defendant number 5ABC. That prayer was not granted by the Honorable Court. Prayer A was granted.
So it is in your opposition.
No, it is not.
No, so what
It's a point of law.
No. If it was done, it should be.
It is their case. It is there. No, it's there in the petition.
No.
They have brought it.
Oh, they have brought it.
They have brought it. But they should have indicated this because once the Honorable Court has not granted that prayer, it is a deemed refusal of the prayer.
Anyway, that is.
Then it is barred. There's a constructive res judicata against making the same prayer again today against defendant numbers 5A, B, and C. They could not have made this.
Division bench
On the merits.
After the Justice Soman Sam granted me.
So it is there in your application.
If my learned friend makes piecemeal submissions like this, it's very difficult for me to make submissions. I'm sure he will permit me to make my submissions.
Virtually.
No, you have completed from your side.
They have completed.
It is
It's
Mr.
my
Park's
it's
turn.
my turn.
Mr. Thakkar wished to join. Let him hear that.
Yes.
That is
Oh,
what I am saying.
oh.
I have joined, my lord. I have joined.
My lord, may I indicate the facts as they stand today? There are 3 things which need to be decided, my lord. Whether this petition at all could be moved by them, number 1. Whether, my lord, they have indicated pleadings where we have stated we are tenants. I'll show from the court's order in the same matter. The court has held that we are licensees. They have not challenged that order. Now today, if they file a suit, they have not annexed the plaint. The pleading is we crave leave to refer to the plaint. Now today, how am I protected under the law? Am I a lawful tenant? Am I a licensee? Am I a trespasser? That has to be decided.
The question is, if the matter has to go for trial, then this application cannot be.
Now for that.
This application cannot sustain.
I'm very grateful.
That is what the court has to decide.
That I'm very, very grateful. For that, my lord, kindly hear me on the facts as stated by them.
Yes.
And I'll quickly show from the written statement and from our affidavit
what they say as a admission under Order 7, Order 12, Rule 6 is not really an admission. And then I'll distinguish Shivani Properties, which they have relied on. They have placed heavy reliance on this judgment, saying this covers us. But what I understand is perhaps this will not be over before this side of the vacation, my lord. If your lordship
Come with
fixes
it,
any date,
come with written notes of arguments also.
will come, my lord. And because I need some time to indicate the facts, because from these documents, their documents, I'll try and demolish their case for Order 12, Rule 6.
আচ্ছা দেখুন 10 তারিখে বা 11 তারিখে কোনো ফিক্স ম্যাটার আছে?
Maybe in the second week of June instead of the first week.
This is long pending, my lord. Mr. Bagh has been dragging this matter for quite some time. Let him conclude his arguments, my lord. We'll reply on the next day and conclude if it commences.
We have to reply also.
Not second week, not any day.
Yes, second week. No, second week.
I'm sorry. Second week after the reopening, but 16th onwards that week.
16-17-তে দেখুন তো কোনো ফাঁকা আছে কিনা?
Any day, madam.
আর 16-তে 2 PM ফিক্স আছে। আচ্ছা তাহলে 16-তে 3 PM কি যে ফিক্স নেই? Yes, record an order.
16, 3 PM.
16. Learned advocates for the parties are present. On the prayer of learned advocate for the defendant, the matter stands adjourned till 16/6/2025. Let the matter appear on the said date at 3 PM.
I'm very grateful. We'll come with the written notes also.
Yes.
And I'll indicate why this is a tribal issue. I'll indicate.
Anyway, you come with your written notes.
We'll do so, my lord.
My lord, may kindly indicate that they will file their written notes before that, my lord. Then
Also submitted written notes. You have not submitted.
They have not. This is not an affidavit that I'll exchange the affidavit. It's a written notes. I'll give it.
No, so my lord, on the ground of written notes, he's taking time today. Kindly record in the order that he'll come with his written notes on the next day. My lord, no further adjournments can be granted like this, please, my lord.
Okay. Parties, yes, learned advocates are requested to submit the written notes of arguments on the said date.
Grateful, my lord.
Notes of arguments. And expedite the matter.
We'll do.
Grateful, my lord. Deeply obliged.
What they are doing, my lord, with all due respect. My lord, I am out of my shop. I can't enter my shop.
This is a 2006 case.
2006, my lord. He is there since 1980, my lord.
Anyway, you come with your written notes, the matter will be expedited. I fixed the matter also.
My lord, if I can't secure justice in my own case, how would I secure justice for my clients?
Definitely. Yes, next.
Item number 39, Lokhi Devi Nathani.
Yes, not today.
Item number 40, Shushmita Banerjee.
Not today.
Item number 41, 21st Century India Limited.
Yes, same.
42, GTN Company. 43, Bhagavati Developers Limited.
43.
Yes, my lord. Group of past defendant, my lord.
Your Lordship, I'm appearing for defendant number 2.
Yes.
I'm for the special commissioner.
You're for?
I'm led by special joint commissioner. I'm led by Mr. Abratush Majumdar, Your Lordship. Kindly keeps it after 1 week after.
Who is for the plaintiff?
I am for the plaintiff.
So what is the stage of this suit?
There is an application made by the joint special officer.
Yes.
Application for they have the receiver for the fixed deposit, and after now the tax department imposing tax upon the previous years. And that's why the application made. They are treated like a representing assets. That's why the application made. Mr. Abratush Majumdar is appearing for.
Your Lordship, one application from our end is also pending, application number being GA7 of 2014, which is for rejection of plaint under Order 7, Rule 11. If Your Lordship, that can be heard after vacation.
My lord, for my lord, for declaration, my lord, because my lord, I am for the defendant number 1, my lord. I have also filed an application for rejection of claim. There are 2 applications for rejection of claim, my lord, another application for my lord, for
So this thing, written statements are already filed.
Yes, already. These applications made by joint special officer will be hard fast. After that,
Yes. Learned advocates for the parties are present. On the prayer of learned advocate for the special officer, the matter stands adjourned till 13/6.
And 1 week after vacation.
Okay,
Kindly fix it.
17/6/2025.
My lord, GA7 is by defendant number 2 seeking rejection of plaint. Your lordship is keeping
Yes.
also that on the
There is
same.
no such urgency with regard to the matter. Let the special officers matter be taken up.
Grateful.
Great. Thank you. Appearance.
Item number 44. Chief Prakash Kajaria.
Lordship, and the substitution application was heard yesterday, Lordship.
No, this is 44.
44, my lord, the
That
main
is
suit
previous week, last week.
Yes, my lord. Yesterday, my lord, the substitution application was heard.
Yes.
My lord has directed after carrying out the substitution, we'll mention the matter for him.
Yes. And this matter is for?
My lord, this is the main suit which is coming.
Okay, this is the main suit. So, you have, who died? This
9A.
So, these persons, this Shiv Prakash Kajaria, they are no more.
No, Shiv Prakash Kajaria is there.
Okay, defendant, one of the
Defendant number 9A.
Okay, so you mentioned after taking necessary steps?
Yes, I will carry out the amendment and thereafter I'll mention for you.
Yes, item 44. Learned advocate for the plaintiff is present. As necessary steps are to be taken in this suit, let the suit go out of the list with liberty to mention.
Lordship, I'm grateful. Who is it?
Item number 45. Virendra Sangvi and others.
Yes, not today.
46. Chiplaksane and others.
With regard to 46, madam, for the defendants, compromise has been entered into by the parties. Madam, decree. I pray for a decree for the original.
My lord,
You are for?
I'm appearing on behalf of the plaintiff, my
Original
lord.
is the
This
plaintiff.
would had already been settled between
All the plaintiffs?
all the plaintiffs.
You are for all the defendants?
Original.
But defendant number 1 is.
My lord, filing
Finally,
original
will
terms
come
of
to page 7. Making payments on behalf of everybody. It's settled by defendant number 1.
Anyway, so the parties have entered into this settlement.
Yes. My lord, will come to para 6, page 7, para 6.
Para 6.
Everything is there. Para 6.2. The defendant number 1 is making the payment for all the.
Page 7. Para 6, yes.
Para 6, defendant accepts 30 lakhs. It is hereby agreed further. Point 2. By and between the parties that defendant number 1 will pay the said amount and on behalf of the defendants to the substitute plaintiff number 1 to 4 for a considered sum of 15 lakhs by banker's check being demanded by NEFT. It has been paid 15 lakhs and the balance will be paid according to the compromise immediately after the decree. The said balance amount of 15 lakhs will be paid after the compromise decree is passed by the Honorable Court. The said terms of settlement will be filed before the Honorable High Court, Calcutta, and it will be jointly paid by both the parties to pass a compromise decree in respect of the terms of settlement.
So all parties have signed it.
Signed.
So far 11 is concerned, it's a limited company. The director have signed it on 11 or
Yes, my lord, my 11.
Defendant 11,
No,
17.
11, my lord.
11, then
No,
12.
Because there was a merger with respect to two companies which are stated. Merger.
11, 12, 13, 14, 15. There was a merger at
Yes.
16. I have the company law both order also here.
So
I
you have
can show.
reflected that in your terms. of
Yes, yes,
service?
yes, 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 yes. I'm
Yes,
showing.
which
I'm showing.
paragraph?
I'm showing. My lord, para 4. Para 4.
Para 4, you have stated that.
Yes, I have stated. By an order that
But
that
actually,
order was given.
the substitution, anyway, that is not carried out. The cost title is not
Substitution by the plaintiff, it was carried out. By the
carried
plaintiff.
out.
Substitution by the plaintiff was carried out.
And amended cost title.
Amended cost title was carried out. Pardon me? Pardon me? Pardon me? Amended cost title, pardon me? Oh, substitution has, as my junior is telling me, has not been carried out, but the order was there for substitution. Subsequently, settlement was arrived. So I think your lord, if your lordship passes.
No, that means you see, if there is a merger, there is a
Yes,
absorption. Who has taken over this
para
company?
4, my lord will come to para
Okay,
4.
para 4.
By an order dated January 5, 2018, passed by the Honorable National Company Law Tribunal, Kolkata Bench, in connection with CP number.
Okay, merge with GS Global Projects Private Limited.
Ujjwal Butter, Pananlal Private Limited, the 11, your lordship was inquiring, Macro Entertainment, Finvest, GS Global Projects Limited, and GS Global Project Limited and merged into it. Here, GS Global has signed.
At present, due to merger, yes, GS Global Projects have acquired the rights.
Acquired the rights. So, GS
So it is signed by
GS Global. He is representing all the things. GS Global is page 11. Your lordship will say, see downwards. Ganesh Singhania. He is the main person. Ganesh Singhania, he has settled and paid the money.
No, but there may be some problems. You see, if you don't carry the substitution,
Substitution
if you go
for
to draw up the decree, that may cause some problem.
Huh?
Anyway, ultimately the terms of settlement is there.
Ultimately, terms of settlement is here, my lord.
Because it's because you see, decree has to be passed in accordance with the terms of settlement. It
My
is
lord.
not that you are withdrawing as the matter is settled outside court. It's not
No,
that.
no, my lord. The decree has to be passed according to terms of settlement.
But some of the parties in the decree, this
because
this person is this company is not here in the cost title. It will not be in the cost title.
Yes,
Global.
Yes, global is
there.
was March.
No, global is reflected.
Yeah, yes.
Okay, 18.
Yes, yes, global is there, my lord. 18.
18.
Global is there.
Okay. In
Every-
paragraph 4, you have reflected that.
I have reflected that. I have given you the order also. My lord, order in terms of the compromise decree and the name of
That
the
means actually it has to be settlement between 1 to 9. If that is or plaintiff's number, you see, it is a terms of settlement between the plaintiffs and
the
defendant number
1
to 17 and 18.
Yes.
No, not only
17.
1 to 17.
Not 18. 4, 5.
18 also.
1 to
17.
1 to 17 and
18. Then this person.
19 also there.
No, 19 is 19 is there.
Is there, and 20, 21, 22 never appeared. It is in the report of this court. 20, 21,
But
20
anyway,
never appeared.
That this court has to record a terms of settlement. So,
yes,
with regard to, you see, 20, 21 and 22, I'll record a submission. No relief is sought for.
No relief is sought for.
No relief is sought for, and it may be dismissed.
They
with
never
regard to 20, 21 and 22.
My lord.
But with regard to plaintiffs and defendant number 1 to 9, there is a terms of settlement. Because you see, after merger, this 18 is already in the record. Only thing is deletion of the names.
Deletion of the names. That can be deleted by if a decree
I granted a liberty to delete.
Liberty to delete to the when the decree will be drawn up by the department.
Because that order is
I have
there.
I have a similar order of terms of service. Your lordship, in this matter, by Justice Sogor, I can show your lordship because the substitution will be carried out. My lord will see the names of the shall be deleted from the constitution. Same thing. The order was passed in a similar compromise settlement by Justice Sogor. Similar. That department will take steps.
That means defendant, the other than global, all may be deleted.
Deleted. All deleted. Plaintiffs. Those who are only entering into settlement will be there.
That means up to 18.
18.
18. No, and 19 also.
19.
So far,
1
20,
to 19.
20, 21 and 22, it may be
never appeared. And
Maybe
there is a
suit may be dismissed. And these are no more. This, you see. So Global Project Limited is merged with.
Global is merged with these three companies. Para 4
Yes.
stated.
Para?
Para 4 in my
Para
compromise I
4.
settled clearly. Minor will see the cost title. Para 4.
Para.
And
Yes.
I've stated. Ujjal Butter, Macro Entertainment, and all these are merged into
Ujjal
GS Global.
Butter, Ramnal Model Trading,
Ramnal Model.
Richard. What the defendant number?
Ramondal Model Trading, my lord, will see defendant number 13. 13 to 17 has been marked. 13, 14, 15, 16, 17. Merged with Global. Merged with 18. 13, 14, 15, 16, 17. Merged with.
Okay, defendant number.
18.
13, 14, 15.
13, 14, 15, 16.
Then?
And 17.
And 17.
Yes, my
This 5.
Yes, in the cost item. Merge with 18. That is GS Global. And GS Global has signed.
Merged with 18. Okay. Yes, it's merged with 18. So 19. Okay, 19 remains. 19 has also entered.
19 has signed. 19 remains.
So 20, 21 and 22
20,
have not.
21 to 22.
And you are not seeking any relief.
No relief.
Yes, take down. Learned. Mr. Banerjee is for the defendant number?
I am for the defendant number. This is a 1 to 5. All balance 8 to 10. All 1 to your lordship records, all to 1 to 17.
1 to 17.
1 to 17.
Except this global.
Except this 20, 21, 22.
No, leave aside this 20, 21, 22.
Global.
Up to 1 to 17 and global, this 18.
Yes, global, I am happy.
Who is representing this global?
Yes, global, my lord, I am appearing.
Oh, you are appearing. Okay, and 19?
19 also I am appearing.
19.
I am appearing as a counsel for all the parties. As a counsel, I am appearing. I am with brief.
Learned advocate appearing for plaintiffs number 1, 2, 3, 4 and
Plaintiff, defendant number.
No, plaintiffs.
Plaintiff.
Yes, I'm recording that. Yes, what is your name?
Shorbani Ghoshal.
Uh,
Advocate on record is Selim Malik.
Okay. Mr. M.S. Shorbani Ghoshal, learned counsel for the plaintiff number 1, 2, 3, 4 and 5, all the plaintiffs.
The plaintiffs.
And Mr. Banerjee, learned counsel for defendants number 1 to 19 are present. It is submitted by the learned advocates that the suit is settled by the parties by plaintiff number 1 to 5 and defendant number 1 to 19 by entering into terms of settlement dated
last page, my lord, 21st May.
Terms of settlement dated 21st May 2025. It is submitted by the learned advocate by producing a copy of the National Company Law Tribunal Kolkata bench in TP number 86 of 2017 that defendant number 18, namely GS Global Projects Private Limited, have merged with defendant number 15, MS Macro Telecom Private Limited, 16, Nirchor Bapar Private Limited, and 17, GKS Finvest Private Limited. Stop. It is further submitted by Mr. Banerjee that by virtue of the merger, DS Global Projects Private Limited, defendant number 18 herein, is empowered to enter into a terms of settlement in the instant matter. So you cannot represent this 15, 16 and 17. That has to be corrected. You are representing 1 to 14, 18 and 19.
15, 16, 17.
Because they are already marked.
Yes, they are already marked.
Mr. Banerjee, learned
They are already
advocate
marked,
for
correct.
1 to 14,
Because-
18 and 19. So 15, 16, 17.
No, because they have already
number-
marked with DS Global.
Yes, yes. 1 to 14, 18 and 19.
19.
Upon hearing the learned advocates submit that a decree be passed in accordance with the terms of settlement. Upon perusing the terms of settlement and upon hearing the learned advocates, this court is of the view that the prayer should be allowed. Thus, I allow the prayer made by the parties. Let there be a decree. Let the suit be disposed and decreed in accordance with the terms of settlement dated 21st day of May 2025. As order of substitution is already passed in this matter, whereby the defendant number 18, whereby the defendant number 15, 16 and 17 is merged with defendant number 18. The names of defendant number 15, 16 and 17 may be deleted from the cause title and records upon proper verification. Let the decree be drawn up expeditiously in accordance with the terms of settlement. Yes, so these names be deleted.
One thing, you should written terms of settlement shall be a part of the compromise. Decree. That is already there.
This terms of settlement will be a part of this compromise decree.
Minor. That will be a part. No, there is not.
Wait a minute.
Item number 47, Dinesh Metallics and Electronics Private Limited.
Lordship, I appear on behalf of the plaintiff. This is the matter where your Lordship on the last
official liquidator has
directed upon
let
the
me see
official
the previous order
to furnish a report, which they did not do, and your Lordship had asked us to send a letter. I don't have a copy of the letter. Your Lordship can look into my copy, your Lordship. This was communicated, this was received, thereafter, no reply. I'm only praying that your Lordship directs the official liquidator or any representative to be here on the next occasion to at least apprise the court as to what is the situation of the defendant.
Yes. Yes, record an order. Learned advocate for the plaintiff is present. It appears that the official liquidator was directed by order dated 24th July 2024 to submit a report as to whether the defendant has gone into liquidation. And the date fixed was on 28th September 2024. Stop. Thereafter, the matter appeared on 2nd January 2025. But no report was submitted by the official liquidator in compliance of the order dated 24th July 2024. On 21st April 2025, this court directed service of all the orders dated 2nd January and 24th July upon the official liquidator for submission of the report, and the same was complied by learned advocate appearing for the plaintiff. Stop. It is not clear as to why the official liquidator, in spite of communication of these orders, have chose not to file the said report. Stop. However, before directing the official liquidator to be present in court, this court is of the view that it would be reasonable to request the learned advocate, senior advocate, who represents the official liquidator to appear in this matter and take necessary instruction from the official liquidator as to the state of affairs. Learned advocate for the plaintiff is requested to serve copies of these orders upon Mr. Ranojit Choudhury, who represents the official liquidator, of the orders passed by this court on different dates, as well as this order. Mr. Choudhury, learned senior advocate, is requested to take necessary instructions, appear in this matter, and apprise this court about the state of affairs.
Of the defendant company.
Yes.
Of the defendant company.
State of affairs of the defendant company. Let this matter appear on 17/6/2025. So serve the copies upon Mr. Ranojit Choudhury.
I will. Great.
I definitely, you know his address and everything.
No, my advocate record will do that. May I just take back the copy? If your lordship requires me,
Yes. Serve all the copies of the orders.
Yes. This also I will.
Yes, this also.
Grateful.
Item number 48, Atmaram Sonthalia.
Yes, not today.
49, Noihati Jute Mills Company Limited.
Plaintiffs, your lordship. I was praying some time to contact my clients.
Okay, item 49, on the prayer of learned advocate for the plaintiff, the matter, the suit stands adjourned till 3rd week of June, 19/6/2025.
Obliged, your lordship.
DKG. Item number 50, PKS Limited and others.
Not today.
51, Sarauki Industries Private Limited.
I'm appealing before the plaintiff, my lord. I'm checking for an adjournment to my lord. Get ready with the matter. It's come after a long time.
So when can you come? Ready?
My lord, keeps it in the June, my lord, will come back.
Okay. On the prayer of, you are for the plaintiff?
Yes, ma'am.
On the prayer of learned advocate for the plaintiff, the matter stands adjourned till 19/6/2025. Learned advocate for the plaintiff is requested to intimate the opposite party advocate by written notice.
Axis Bank Limited.
Yes, not today.
53, Lakshmi Rani Sarkar and others.
Lord, I am for the plaintiff, Lord. It is a suit for partition, Lord. Lord, actually, when parties are settled between themselves, the party. Lord, I have prepared the terms of settlement.
How many parties are there?
Lord, there are 3 parties. Plaintiff 1 group, defendant number 1 and 2.
My lord, I am appearing for defendant number 1, my lord. Previous advocate on record, Prabir Kumar Chaudhary died, my lord. Thereafter, my
You are representing the defendant number 1.
one
The former advocate was Probit Chaudhary.
Probit Chaudhary who died, my lord.
died, my lord.
Anyway, you are now representing.
My lord, department not accepted my Wakalatnama. They asked date of death of Prabir Kumar Chaudhary. My lord, it is not possible to know the date of death of Prabir Kumar Chaudhary. My lord, I am praying.
He is a member of the Bar Association.
Uh,
If he is a member of the Bar Association, you can ascertain from the member.
Kindly give me leave, my lord, then so that he can file the Wakalatnama in the department.
my lord.
And who is representing the other defendant?
The other defendant, Mr. Ranjit Kumar Basu.
So better serve him, okay? Serve notice and come.
He signed the terms of settlement.
Let the order be passed in his presence.
Okay.
My lord, give
My lord,
date to file.
Yes, yes. Learned advocate for the plaintiff and learned advocate for the defendant number 1 is present. Leave is granted to the learned advocate for the defendant number 1 to file the Wakalatnama. Let notice be served upon learned advocate. I am representing the defendant number 2. Let this matter appear on.
Let's keep it on 23rd, my lord. I will serve a notice.
No, it's better to keep it after vacation. On the reopening, 10/6/2025. On the following day, next day after the vacation.
My lord, instead of 10th, my lord, make it 11th.
Okay, 11/6/2025.
Let it appear as terms of settlement.
Anyway, it will remain in the list, in the same position.
Avanti Corporation 55, Coco Pistas Corporation Limited 56, Sri Kishan Binani and another 57, A.P. Mullah Mark A.S. and another 58,
57.
Vishnu Pada Vishwas.
For 57, my lord, I appear for the plaintiff.
57.
Yes, my lord.
Yes.
My lord, I appear for the plaintiff, my lord. By the last order, His Lordship Justice Krishna Rao was pleased to transfer this to the commercial division, my lord. The matter involves a commercial dispute. If my lord kindly takes up the last order.
Oh, my suit is already transferred.
But by the last order, this suit.
So how this is appearing here?
But perhaps since Justice Rao had determination of all the suits, commercial and non-commercial, perhaps this has come. But kindly takes up the last order.
Okay, the entire suit is transferred. That is Justice Mojumdar's order.
Yes, my lord. I stand correct. Justice Mojumdar's order.
Yes, record an order. As this suit was already released from the list of Honorable Justice Sugato Mojumdar with the observation that it involves disputes of commercial in nature, let the records placed before the bench having determination to take commercial suits. The suit stands released from this list.
Grateful, my lord.
Item number 58, Vishnu Pada Vishwas and others. 59, Abhishek Bose and others. 60, Shenmo Engineering Limited.
Lord, I appear for the plaintiff in this matter, my lord. I need to, Lord, we all have to go through the papers and take instructions. After vacation, your lordship, may kindly.
60.
60.
Okay, 60 on the, you are for the plaintiff.
Plaintiff.
On the prayer of learned advocate for the plaintiff, the matter stands adjourned till 18/6/2025.
18/6.
Learned advocate is requested to intimate the opposite party advocate by notice.
Yes, ma'am.
61, All India Trinamool Congress Party.
Not today.
62, Bharat High-Tech Siemens Private Limited.
I appear for the plaintiff, my lord. I'll be requesting for a same prayer.
Yes, same order as item 60. Item 60 ওই অর্ডারটা করে দেবেন।
Extremely grateful, my lord.
18-6. 63 তো? ভাই 63 তো? 62. 62. 62 ভারত হাইটেক। আচ্ছা। আচ্ছা। Item number 63.
Not today.
64, Marlin Projects Limited. 65, State Bank of India.
I appear for the plaintiff, my lord.
65, you are for the plaintiff.
Yes, my lord. My lord, I am praying extension of time to file my affidavit and document. My lord, it could not be filed because, my lord, there is fire hazard in temple chambers. And for last 1 month, we are suffering without electricity.
Your
Lordship, I am objecting to the extension. My lord, your lordship will kindly have a look at the last order, 22nd April. 4 weeks have passed.
My lord, for last 1.5 month, we are suffering without electricity.
You're for the defendant.
My lord.
Yes, record an order.
My lord,
Learned
kindly
advocate
record my objection.
for the plaintiff and learned advocate for the defendant are present. Learned advocate for the plaintiff prays for time to file affidavit of documents which is objected to by learned advocate for the defendant. However, in the interest of justice, such liberty is granted as a last chance. The affidavit of documents shall be filed by the plaintiff on or before 26th of June, 26/6/2025. Let this matter appear on 27/6/2025. Acha, 36/2025. 30th of June. But do the needful within 26.
I'm grateful, man. I'm grateful. Mother.
For hearing 66, Madhavi Malik and another.
No, there is 66 and 67 together, my lord. My lord, on the last occasion, I had filed the report that exception to the report was given by the defendant number 10. So I filed a report on behalf of the commissioner, partition commissioner. And the report is kept with the records, my lord. And I've given all that. Kindly go through the report, my lord. It is self-explanatory, my lord.
I am appearing on behalf of the defendant, all of the defendant except defendant number 10. And the application for expunging the name of the defendant number 6 has already been filed by that is just lying in the master court for scrutiny. Defendant number 1, 2, 9 and 11 and 12. The defendant number 6 has been expired. But I made an application for expunging her name on the ground that those.
Who is for the plaintiff?
Plaintiff but today is not appearing.
Plaintiff is appearing, I think, my lord, on
virtual mode.
Video conference, virtual mode. আসছে কি? আগের দিন ছিলেন। Yesterday he was there, my lord. Today he's...
Anyway, let it be taken up after vacation. It will take some time.
Yes,
My
grateful,
lord, my lord.
Yes. Learned advocate for defendant number 1 to 7.
1 to 9 and 11 and 12. Except 10, all of the defendant.
For the appearing for defendant number 1 to 9.
And 11 and
11 and 12. And learned advocate representing the special officer. You are for the?
I'm the partition
commissioner.
Learned advocate representing the
partition commissioner.
Partition commissioner.
My lord.
And
Lordship, I appear on behalf of the defendant number 10.
learned
I
advocate,
appear for applicant in GA 15, my lord.
learned advocate for defendant number 10 are present. None appears for the plaintiff. In the facts and circumstances, the matter stands adjourned till 11
Yes.
6 2025.
11 June, my lord.
Yes, yes. For hearing.
Lordship,
Yes, GA, you are for?
I'm for defendant number 10. Lordship, may kindly keep it for hearing because there are two applications, my lord. One is my application challenging the appointment of the partitioner commissioner, and the other one I think is by a party who wants to be sought added in this partition suit, my lord. It has some importance, Lordship. May it enjoy some priority in the list, Lordship. I will humbly pray.
What is your application?
Addition of party.
GA?
GA 15.
GA 15 of 2024. What is your application?
Mine is GA 16, my lord.
GA 16 of 2024 be
Four.
4.
Pleadings are complete here, my lord.
These applications will be heard on 11/6.
My lord. My
Yes.
lord. My lord. I'm grateful.
But the plaintiff by notice.
My lord.
But objection.
The report is kept with the record, my lord.
Yes, that is done on the earlier occasion.
My lord, my lord.
Only one thing, my lord, the defendant number 9 has suppose died. 9.
6. I already been made an application, but not grateful.
You move that application on the next day?
Next, yes.
Grateful, my lord.
All arguments fixed at 3 article number 68. The proofs of Sunita Devi
Jagatramka.
Jagadrambha.
Yes, evidence is complete in this matter.
My lord.
Let me see the records.
Lord, all the formalities done, my lord. The citation was.
You have examined 2 witnesses.
My lord.
Okay.
Citation issued, my lord. Served to all the parties. Nobody appeared. No objection.
Citation was issued.
Yes, special citation, then general citation.
So this is okay. These are the legal years. Para 4.
Yes, my lord. They are legal years.
Citation was issued.
Yes. And nobody has appeared. We have filed affidavit of service twice. Then the other two legal years could not be served. Then publication newspaper. Again, affidavits of compliance filed. It's all in the record, my lord. And there are 3 orders, my lord.
Application of which year?
14, my lord. 2014.
2014.
But twice publication was made. Affidavit service was filed. And my lord, there are 3-4 orders. And the last order, my lord, of my lord, Mr. Somin Sen. This is a non-contested matter. It may be.
Where is that order, please?
7 June 18. If my lord kindly see. I have given a bunch of paper, my lord. IT is there in the last page. You know a bunch of paper, Kindly see the last page, my lord.
Yes.
Last page. Last page. Order of the 7th June 2018.
Yes.
The affidavit of service filed by the petitioner is taken on record. It appears that inadvertently the special citation has been published in the Calcutta edition of the statement. So, however, having regard to the fact that the special citation has been published on Times of India, have been wide circulation in so is dispensed with. Matter is adjourned on so when the matter will be treated as a non-contested matter cause. In the event, no caveat is lodged by any of the legal years in the meantime. The department shall file a report indicating where any caveat has been filed.
So, from when this matter is appearing as non-contentious, that order?
My lord.
Now, what is that order? Treating this matter as non-contentious? Oh, adjourned.
Yes.
So, any report that whether any caveat has been lodged? No, this adjourned. Okay, the matter was adjourned till 15 June.
Thereafter, it was not listed.
Yes, but No, it is observed that in the event no caveat is filed in the lodged by any of the legal heirs, it will be non-contentious case, and the department shall file a report. Did the department file any report?
No, I have not seen কোন report আছে?
Any report as to whether any caveat was filed?
Report আছে file? Any report by department? No caveat.
Anyway, then I can do one thing.
My lord.
Hearing is concluded. Only this order is not complied by the department. I can direct the department to file a report on the reopening date.
My lord.
And thereafter, I can pass necessary orders.
আছে?
No, yes or no, whatever it is.
No,
If
yes.
they would have, if there is any caveat, yes. If there is no caveat, no. But something should come.
Yes, yes. There is no caveat. I know there is no caveat.
Anyway, but it ought to have been filed.
The report we called, my lord.
Yes.
The report, if it is not there. Okay.
Learned advocate for the petitioner executed is present. In the instant case, the evidence is complete. It appears from order dated 7th June 2018 that from the order dated 7th June 2018 that the department shall file a report indicating whether any caveat has been lodged. Stop. However, there is no report by the department in terms of the order dated 7th June 2018 as to whether caveat has been lodged in the instant case. Thus, the department is directed to submit a report on or before 12/6/2025 as to whether a caveat has been lodged in this case. Let this matter appear on 16/6/2025.
Fix time, my lord, at 2 o'clock.
16/6. It is a short matter. It will not. Acha, let it 16/6/2025 at 4 p.m.
As the lordship, please. My lord.
For framing of issues, item number 69.
My lord, I appear for the plaintiff in this matter. My lord, by your lordship's last order, we were directed to file the affidavit of documents. Lord, I was humbly seeking an extension of.
Therefore,
Lord, I am for the plaintiff. Lord, we were directed to file the affidavit of documents. My lord, I am humbly seeking extension of the time to file the documents.
Let me see the order.
For the defendant in this matter. Twice they have taken time. Twice they have taken time for filing affidavit of document.
My lord, this is the first extension that we are seeking. My lord, kindly seize the order of 22nd April 2025.
There was a previous order also. The order dated. Okay.
Anyway, you file it on the next day. You see, this is a 2012 suit.
Yes, my lord. My lord,
pending for a long time.
Lord, we shall expedite it at the earliest. My lord, kindly give us a week or 10 days after the vacation. My lord.
Learned advocates for the plaintiff and learned advocate for the, you are for all the defendants.
And for all the defendants.
For the defendants are present. Learned advocate for the plaintiff prays for time to file affidavit of documents. Such prayer is allowed. Let the affidavit of documents be filed on or before 19/6/2025. 19/6/2025.
Lord, will it be your lordship's pleasure to give us 2 weeks complete, 23rd, by 23rd? Lord, court is reopening 9th.
By 23/6/2025.
Grateful, my lord.
Let this matter appear under the same heading on 25/6/2025.
Grateful, my lord.
The next matter, same.
Yes, my lord. Item numbers.
Item 70, same.
Same, my lord.
Okay, item 70 also same order. Alada alada kore kore.
My lord, before my lord takes up the next matter, my lord, item number 60 and 62, my lord, I was for the plaintiff, but I was stuck in the online portal, my lord. I could not enter the meeting, my lord.
60 and 62 have adjourned. Okay.
After vacation, my lord.
Yes, yes, after vacation, 60, 62, because defendants also short time, I have adjourned it. You see when is the next date fixed.
Okay, my lord. Deeply obliged. Deeply obliged.
মানে যে পিকআপ করেছে না কি? জি খুঁজবো পাবো।